All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning and welcome, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Gucati&Haradinaj.
Thank you. I noticed that Mr. Potch has rejoined us today. Anybody else? No. Mr. Rees, any additions?
Ms. Stevenson has returned and is back in court.
Mr. Cadman?
And Ms. Chelsea Koo has returned and is back in court.
Thank you. I note that Mr. Haradinaj and Mr. Gucati are both present in the courtroom. And before we bring back the witnesses, the panel will address a few matters. First, the panel notes that the SBO filed yesterday its submissions on the associated exhibits as ordered last week. This is filing F-397. The panel also ordered the defense to indicate orally or in writing which of those exhibits it objects to by close of cross-examination. Mr. Rees, Mr. Cadman, we are assuming that the cross-examination finishes today. Will we get a written filing today, or will your objections be presented orally later?
We'll make oral representations.
All right. Well, in effect, that's giving you a little more time because you don't have to file immediately, and that's all right. We will listen to your oral objections when we get to the admissions stage. Mr. Cadman, you wanted the floor?
Your Honor, just before the witnesses called in, one matter. Obviously, we had filed the application for an additional expert witness. So as not to delay matters, we will need to put formal written instructions to the witness. But of course, we will need an indication of whether we are going to be permitted to do that or not.
And we will get to that. Thank you for reminding us, though. As just mentioned, the panel notes that it was seized since yesterday with an application of the Haradinaj defense to add a new expert witness to its list of potential witnesses and to direct that an expert report be filed excuse me, with a deadline of 14 days. The application is F-394. In the interest of expeditiousness, the panel orders the Haradinaj defense without hearing from the SBO on the present application, to file the new expert report by 9 November 2021. The prosecution is instructed to follow the procedure set out in Rule 149 Sub 2 and file any notice within 7 days of notification of the report. This concludes the oral order on the report of the new expert witness. So now, yes. Oh, go ahead, Mr. Cadman.
Certainly the timeline is acceptable. The only question would be, bearing in mind the SBO have raised objections in relation to the first expert as to the material that should be put to the expert in order to prepare a report. I'm more than happy to liaise with the SBO on what matters or what documents should be provided to this particular expert.
We always encourage that. Thank you very much. Now let's continue with the witness. Madam Court Usher, please bring Ms. Pumper in. You can be seated, Ms. Pumper. Good morning. Today, the defense will continue and finish its cross-examination. The SPO indicated that it wishes to ask you a number of questions in re-examination. Then the members of the panel may have a few questions for you. Our plan is to finish your testimony today.
Thank you.
Mr. Cadman, you have the floor.
Good morning, Ms. Bumper.
Good morning.
As Mr. Rees had indicated prior to the start of his cross-examination, I will just say the same. If there's anything that you don't understand, anything that you're not able to answer, then please do so indicate.
Thank you.
I will do my best to maintain the position that we don't need to go into private session, but obviously there may be aspects of, and I'll be guided by the panel, there may be aspects that we may need to go briefly where we mention individuals' names. So just a few points of clarification that should be fairly non-controversial to start with. So first of all, it's right that you were not present at the search and seizure on the 8th, 17th and 22nd of September of 2020.
That is correct.
And on the 25th of September, when you coordinated the search and seizure operation that we saw yesterday, you did not come into contact with either Mr. Haradinaj or Mr. Gucati on that time.
I did speak to Mr. Gucati.
But he was not present during the search and seizure operation.
No.
And it's also correct that at no stage have you either formally or informally questioned Mr. Haradinaj in these matters.
No, I have not.
And you were not present during his arrest on the 26th of September either.
Sorry, I'm not sure whether I understand. He was arrested on the day of the search.
But you were not present when he was arrested.
He was arrested at the War Veteran Association, so I believe I was there, yes. But I was not involved in the arrest, if that is your question.
What I'd like to look at now is your professional background. You previously held the position as an investigator in the Austrian police force for a number of years, that's correct?
That's correct.
And subsequent to that, you served in a number of UN and EU missions, as you've told us.
Yes, one EU mission.
So one EU mission.
Yes.
First of all, you were assigned, whilst you were still an Austrian serving officer, to the UN mission in East Timor.
That is correct.
And you've also served in DRC,
Correct.
Haiti,
Correct.
and Ivory Coast.
Correct.
In East Timor, you progressed to become a team leader for the War Crimes Investigation Unit.
That's correct.
And amongst your responsibilities were crime scene management and securing evidence.
To a lesser extent.
Then, from 2009 to 2015, you were, as I understand it, an executive police officer with the EU mission on financial investigations.
Both financial investigations and organized crime.
Mr. Cadman, we've been asked to have you slow down just a bit in your
I do
delivery.
apologize. And during your time in Kosovo, you led a number of complex investigations.
That is correct.
You were responsible for preparing work plans,
Correct.
evidence analysis,
Correct.
interviewing witnesses and suspects,
Correct.
utilizing covert measures,
Correct.
executing searches and arrest orders,
Correct.
and drafting preliminary and final investigative reports.
Correct.
Around this time, you also undertook academic study at Leicester University, is that correct?
Yes, long distance.
You did a master's in criminology and criminal justice.
That is correct.
You then moved to the SITF, where you were there for a period of 5 months.
Correct.
Under, at that time, it would have been under David Schwendeman and Kwai Hong Ip.
Correct.
Could the counsel and the witness please pause between answer and question? The interpreters kindly ask because at this speed it is impossible to work.
And Kwai Hong Ip, you joined the SBO, where you are now an independent investigative consultant.
Excuse me, would you please repeat because I had a message.
Yeah, excuse me, Mr. Cadman and both witness, both of you pause after the question so that the translators can keep up with the delivery.
So I'll ask the question again. In 2016, you joined the SPO. Is that correct?
Correct.
And that would have been under David Schwendeman and Kwai Hong Ip at that time,
Correct.
where you are now as an independent investigative consultant.
No.
So your position now, as you've said in evidence, is as an investigative coordinator.
My position is investigator, but internally I have the role of investigation operations leader.
And in both your evidence in chief and cross-examination, you made a point of telling us that you have 20 years' experience in your field as a senior investigator. So it's fair to say you're an experienced investigator.
I have 20 years as an investigator.
But in this case, your evidence is that you were deployed to conduct data analysis.
Would you please specify?
Well, what you've actually said is that you were asked to review the 3 batches and confirm whether that material was contained within your Xylab system.
Yes, sorry, I didn't understand. If you refer to the batches, I was tasked to analyze the 3 batches, correct?
And as you said, when questioned by Mr. Rees, as to further analysis of the content of that material, you didn't stray outside of what were your instructions.
No, I did not.
But that doesn't really stack up with your background experience, does it, Ms. Pumper?
I'm not sure what you mean.
Well, you've been an experienced
It's
investigator.
an objection, Your Honor, on this. It's argumentative.
Overruled. Continue.
My question is that, as we've just seen, you are an experienced investigator, and in this case, you were instructed restrictively to do data analysis. My question is that that doesn't really stack up with your years of experience as progressively a senior investigator.
For me, there is nothing unusual to be given specific tasks. Sometimes it's one thing, the other time is a more demanding thing.
I just want to go back for a moment to the arrest of Mr. Haradinaj. You said that he was arrested at the WVA.
Sorry, maybe we misunderstand. I meant Mr. Gucati.
I said Mr. Haradinaj.
Excuse me. Her answer previously was Mr. Gucati was arrested in her presence.
Yeah, my question was in relation to Mr. Haradinaj.
I apologize, I misheard.
So you were not involved in the investigation, in the arrest in any shape or form?
No, not of Mr. Haradinaj, of course.
In your evidence, under cross-examination from Mr. Rees. You've said that previously you've never used a disclosure officer.
I would like to ask the counsel to refer to the specific answer given by the witness. I don't think she said so.
Microphone, please.
Please do so. Please refer to the specific question that was asked.
Well, Your Honour, whilst we identify where the witness actually said that, let me put this question to you again. During the course of your engagement on this, have you ever had cause to use a disclosure officer?
In this case, you mean?
Yes.
Just please bear with me a moment. No, I don't think so.
Just one moment, Your Honour. And again, we'll come back to the reference in due course, but your evidence has also been that when you received the third batch of the material, you received that batch from from the case and management officer, I believe the person who's sitting on the second row of the prosecution table now. That's correct.
I think this is the evidence that was provided by the witness, and I would ask to refer to the specific part.
Now, you can answer the question, overruled, if you know.
If I may ask if you can be more precise when you mean when I received the evidence?
Well, in your declaration and a matter that came out in evidence, you said that the material that you received to review batch 3 was presented to you by the case and management officer, the person who's seated in the second row of the prosecution table.
If I may say, I have submitted the evidence into the case management unit and I reviewed it from the Xylab system.
Now, going back to the first point, just to remind you, in the transcript of the 21st of October, page 1191, at line 5, question was put to you: is there a specific role then in an investigation for a person who is responsible for making sure that material which might help an accused in any investigation or prosecution is brought to the attention of the prosecutor? Your answer was, I'm not aware.
And I believe I also said that I would do that in any case. And I believe that later on I also clarified that I understood now that you are referring, or Mr. Rees was referring to the exculpatory review. It took me some time to understand where this is going to.
Well, let's go to line 10. In your previous work, in your previous experience working for ULEX, were you aware of the designation of a disclosure officer in cases as a normal operating procedure? Answer, I was not. Question, so that we understand, it's not part of the normal operating procedure of the Special Prosecutor's Office to designate an individual as a disclosure officer responsible for bringing material which may help the accused to the attention of the prosecutor. Answer, I'm not aware of that. I can't confirm or deny. So your evidence was, on the 21st of October, that you are not aware, nor have you had cause to use a disclosure officer.
All until I started working for the SPO, my experience did not involve any case going in the trial phase. My experience is investigating until indictment, and then I move on to the next case. This is my first experience with a disclosure team.
So, in all of your 20 years' experience, conducting investigations, working with prosecutors, at no stage have you ever come into contact with a person who may come under a different title, but a person who has the function of a disclosure officer?
When I was in ULEX, I did come in contact because I had to help paginating the evidence in one of my cases. But that was the limit to it.
Okay, staying with the transcript of the 21st of October, where's the page? On page 1196, you were asked, so Ms. Pumper, are you really saying that as an experienced investigator of some 20 years, you are unaware of the role of a disclosure officer? Your answer was, that is correct.
That was my answer.
Now, we know that you have had reason to coordinate with the case and evidence manager, whose name I won't mention, so that we stay in public session. But what I'd like you to do is to look at, and if we could bring up on the screen, Madam Court Officer, DHG 0231 to DHG 0246. Oh. Apologise, that's the wrong one. Just 1 second. Do apologise. DHG 247. Now, as you can see, are you able to see that?
Maybe we can make it a little bit bigger.
The only part that I'd like you to look at, so if we look at the headline, so it's a vacancy for an associate case and evidence manager.
Yes?
Then if you have a look on the left-hand side under the blue line where it says reporting line, it says reports to the legal officer for disclosure. That would indicate a position within the SPO of a person who is responsible for disclosure?
I don't know these details.
You have never come across anyone that holds that title in the SBO before?
I can't confirm or deny.
You have never been made aware of that person?
We have a team.
A team that is completely oblivious to you?
I don't say it's oblivious. You ask me for whether I know what they do. I don't know specifically what they do. I know they exist.
Let's move on to your role in this investigation. As you've said, your role is as an investigator, currently a general investigator, and informally an investigations coordinator.
Investigations operations coordinator.
Operation. And I assume you're not involved just in this case.
That is correct.
And in your capacity, you would undertake a range of functions, including analysing and reporting on evidence,
Correct.
conducting a review,
A review of
a
what?
review of the material,
Of evidence. Yes.
conducting witness interviews.
That is correct.
Now, I don't want to mention any names of cases that would require us to go into private session, but in terms of the cases you've worked on, it's right, is it not, that none of the present investigations or present public investigations or cases relate to any Serbian accused. That's correct?
That is correct.
I would object in general to any line of questioning that goes to the contents of SPO investigations.
Overruled. Go on.
The witness has answered, so her answer can stand on the record.
Yes.
I'm grateful, Your Honour. And it's right that you have led parts of this investigation, even if you may not have been at the top of the chain of command.
That is correct.
Certainly, as we saw yesterday, you had coordinated the search operation, albeit not resulting in anything tangible, but you had led that operation on the 25th of September of last year.
That is correct.
Now, you've said that your first involvement was on the 25th of September in relation to that search.
That is correct.
But it's also correct, and it must follow, that your instructions would have come several days before that.
It was not several days, I believe, to conduct it. Was the day before or 2 days before, if my memory serves me correctly.
And you were here in The Hague when you received those instructions.
No, I believe I was in Kosovo when I received these instructions, but that can be checked. I cannot be 100% certain.
Perhaps if there is a way for you to check during the first interval, it would be helpful to know where you were when you received those instructions.
I believe there was an order from the presiding judge that the witness should not be tasked to conduct further researches in order to testify.
Sustained. Just answer the question to the best of your ability.
I believe to recall I was in Kosovo.
And in fact, you were in Kosovo on the 22nd of September, were you not?
I prefer not to guess. I cannot be sure whether I was already at that date in Kosovo.
Well, let me put it to you that you were in Kosovo on the 22nd because Mr. Haradinaj, in the company of 3 German KFOR officers standing on his balcony, actually saw you in Pristina on that day. That's correct, isn't it?
Objection, Your Honor. It's not evidence in this case that Mr. Haradinaj ever saw the witness in Kosovo on the 22nd of September.
Sustain, you're asking her to assume something that is not in evidence?
Now, going back to the start of this investigation from the 7th, who had overall responsibility on the ground for that investigation? We may need to go briefly into private session, as I will need to mention some names.
Ready at this time?
Yes.
Your Honor, we're back in public session.
Thank you. Continue, Mr.
Thank you.
Cadman.
So, sharing an office with Officer X, like any normal person, you would exchange views and you would presumably talk.
Yes, we would talk.
exchange views on topical issues?
What do you mean with topical issues?
Well, did you just have general conversations with him? Things that interest you?
Talk.
Talk about work?
Yes, we talk about work.
Talk about the office?
I guess so.
And as an investigator, both of you have worked in different institutions in different parts of the world. I'm sure you exchange war stories.
Not really. Officer X is not that talkative.
Sharing an office with him, obviously we will try to be discreet, but I'm sure you overheard conversations that he had with other people.
I don't remember anything specific, but I'm sure I did.
And like any functional office, communication is an important part of the role of an institution such as this.
Could you repeat that, Mr. Cadman? Your hand hit the
I'm
microphone.
moving away from the microphone. I do apologise. Bad habit. Like any normal office, any normal functional office, communication is key.
Your Honor, it's argumentative and generic as well. Also, it's not clear what's the relevance of these questions. They are beside the scope of the examination in chief, and I would like to understand what's the defense case that is being put to the witness.
What is the defense case you're putting to the witness?
Your Honour, I'm trying to establish that this witness has said that she had no communication, had no discussion. I'm trying to establish how the office actually functioned in terms of how it was organised and how they communicated.
I'll overrule your objection for now. Get on with it.
The question is, as I've said, any functional office operates on communication, probably none more so than a prosecutor's office. Would you agree?
I agree that communication is an important thing in office.
And this would have entailed regular team meetings?
That is correct.
Do you have a listserv in the SPO for updates on relevant matters?
There is an objection. It really goes to internal work product about the organization of the office.
Your Honour, if I can respond before you rule, I'm not asking this witness to identify anything confidential, only exploring what means of communication they had in the office. That does not disclose how anything confidential as to how the organisation operates.
The objection is overruled. You can continue.
Would you please repeat the question?
I had asked whether you have a listserv for communicating information on important events.
I don't know what listserv means.
Okay. Do you have a system where information is communicated office-wide on a regular basis, or is there a tool that you can access that provides information on important matters affecting the office?
We have a Friday meeting every week, weekly Friday meeting, and we have meetings on projects, so we have teams assigned specific projects. They meet regularly. All in all, I would say that we have a regulated line of communication in this office.
And so, if a significant matter occurred, there would have been a forum by which that information would be communicated to all staff within the SBO.
Objection, Your Honor, it's speculative.
Sustained.
Now, we know that the events that surround this case, if we are to accept the prosecution case, presented a major issue for the SPO from the 7th of September. Is that correct? Is that a fair question?
It was an issue, yes.
When were you informed?
I think I said before, I don't remember when I became aware of it. But I became aware of it, and it was an issue we talked about.
Certainly, as a senior member of the office, around the 7th or the 8th of September, you would have been made aware.
Like, I have to repeat, I would just speculate. I don't remember when I was made aware, but I was made aware.
And sharing an office with Officer X at that time.
Your Honor, I'm not sure whether at the time the witness said that she was sharing an office with the Officer X at the time. Can we establish whether the witness was in the office at all at the time?
Try to be specific about your
Certainly.
question.
Were you sharing an office with Officer X at that time?
If I can just be clear, so yes, we indeed have one office, but that does not mean that he was there or I was there. We have our desks in this office. I don't recall whether he was specifically in the office that time.
Do you recall him travelling to Kosovo on the 16th and again on the 22nd?
No, I don't recall that.
At no time did he tell you that he was going to Pristina at that time?
This happened a year ago. I really have no recollection.
Now, I know you've said that he wasn't a particularly talkative person, but you must have been aware of his professional background to some extent.
To some extent, yes.
Your Honor, we're back in public session.
Thank you. Mr. Cadman, you can continue.
So I'd like to move on to the organisational structure and the internal rules of the office. So the SBO has been operating since 2016, and you've been here effectively since the beginning.
Correct.
The SBO inherited a mandate from SITF.
Correct.
whilst I don't imagine you to be aware of the specifics, it obviously has a significant budget considering the size of its operations.
Objection, Your Honor. Argumentative is asking for speculation about the budget of the institution.
It's irrelevant whether they have a budget or how much it is.
The point is that it's a relatively large operation, and you are aware of that.
It's asking for an opinion, and it's not clear what the comparison the Council has in mind is. Relative large in comparison to what is irrelevant in general.
Overruled. You can answer that question if you know.
I have no comparison. I don't know whether you would call that large, medium, or small.
Okay, not pressing you on the size of the operation, you would agree that an operation of this kind requires a level of organisation.
I can confirm to the positive.
And you would also agree that such an institution, there's a need to record key activities that relate to criminal investigations.
I would agree, yes.
And in case any questions are asked, there needs to be a documented record of what happens in a particular case.
If you can just explain to me what you mean with what happens in a case.
Well, you would agree that in a prosecutor's office you need to maintain effective records, documented records of all actions that are taken in a case, in case any questions are raised at any stage.
I don't know what level of record you are looking at, but for instance, information obtained has to be processed, submitted into evidence. Whether you refer internal communications, I think that is individual from organization to organization. Depends on the leadership, really.
Now, you have said on more than one occasion that your instructions were provided to you orally by Ms. Bellici. Is that correct?
I actually thought of this, and I believe I also have email communications. I'm not sure whether I said that at the time.
Well, we can come back to that after the break, perhaps, but what you had said was that you had been provided with oral instructions and no contemporaneous note was made as a result of those oral instructions.
I did not make a contemporaneous note of the instructions.
But now you're saying that there was an email communication from Ms. Bellici providing you with your instructions in this case.
There were email communications. Now I remember. I apologize. It's a year ago. I'm trying my best. There was a combination, oral and email communications.
And was that just from Ms. Bellici, or did you receive written instructions from other members of the prosecutor's office?
I remember at least one more email communication. It's not an instruction, it's just providing some information for me to review.
Who provided that instruction?
Shall I say the name?
Well, let me ask, well, wait for the judges to rule before you look to Ms. Bellici for assistance. Did that instruction come from Ms. Bellici?
That comment is not necessary. Just confine yourself to question.
Certainly. We can go into private session so she can answer that question, Your Honour, perhaps.
We will go into private session.
Apologise.
Your Honours, we're back in public session.
Now you can proceed, Mr. Cadman.
What was the nature of those instructions?
I received an email pointing me to the files where these communications are located, which I needed to draft paragraphs, I think 32 to 34 of my first declaration. There was a consolidated folder, so it was easier for me to review it. There was no instruction to it.
Now, staying with internal procedures, as a general point, would you accept that a prosecutor's office such as this can only function adequately with proper internal guidelines and protocols on matters that relate to the functioning of the office and the conduct of investigations?
Objection, Your Honor, it's argumentative.
Overruled. You can answer the question.
Well, this is like a general question. I can confirm that from my perspective, we have a functional communication line and organization in the office.
The question's not about communications. We've heard you on that. The question was about internal guidelines and protocols that exist in the office on different matters that relate to the internal structure of the office and the conduct of investigations.
In relation to the internal structure, yes, there is an internal structure in the office. And in relation to guidelines for investigations, I think I said, I don't recall having seen anything written to that effect.
You've never seen any written guidelines on the conduct of investigations or any other aspect of your work other than how the organisation is structured?
You're referring to a very broad topic, so I can say, for instance, we have guidelines that when we travel, there is a certain amount of paperwork which needs to be approved beforehand, needs to be filled in. When we interview people, there is a certain process, how we get there, how we prepare for it, how we have meetings with management discussing how to go about. When we finish them, we come back, we report on the outcome. On the submission of evidence, there is a clear procedure. So, like generally speaking, I don't think we have an issue. So if you want to ask me specifics.
Well, I'm asking you this because, again, we may need to come back to the point in which you answered this question previously. You had said that you were unaware of the existence of any such protocols or guidelines.
If I remember correctly, and I apologize if I misunderstood, You were referring to something like guidelines on how to conduct investigations. We do not have guidelines how to conduct investigations. We have guidelines, like operational guidelines, how to go about it.
What about guidelines on search and seizure operations?
We have guidelines on search and seizure operations.
Guidelines on internal security matters?
We have guidelines on internal security matters.
And at what stage were you made aware of those internal guidelines? When you first started in the office?
The security guidelines?
And the guidelines that we've just listed, when were you made aware of the existence of those guidelines?
The security guidelines I was made aware immediately when I started. It's part of the induction package. Then we talked about the search and seizure guidelines. That I was involved in development. What was the other one? I apologize.
Search and seizure?
Search and seizure, I was part in developing those.
You were part of developing the rules on the search and seizure operations?
Not the rules, the
guidelines?
Yes, yes.
Now, I want to go back to what happened during or immediately after the 7th of September. And recognizing that this was, by your account, or by the SPO's account, a significant data breach. Did the prosecutor call an office-wide meeting to inform you all of what had happened?
Your Honor, I believe the question has been asked and answered already.
Overruled, you can answer.
I would need to clarify. We were at one point, we had an office meeting where the chief prosecutor, the specialist prosecutor made an announcement, yes.
And when was that?
I don't remember the date.
So an office-wide meeting where you are informed about the breach. The data breach. You were informed by the specialist prosecutor.
That I don't remember, no. I don't remember that that there was an office announcement that there was the breach. I don't remember, but there was an announcement sometime later about the data breach.
And was that an entire office, or were you in a smaller team when you were informed of that?
That was the entire office.
What further steps were taken following that announcement? Well, let me ask that in a little bit simple terms. Were any further steps taken internally as a result of that data breach?
As I said, I don't recall that the prosecutor, special prosecutor, announced the data breach, but what I do recall is that we had an amendment to our security procedures and protocols subsequently to that incident.
Now, we've also spoken about the size of the office. You're not with me that it's a large office. Now, my question is this. At some point between September and December of 2020, a number of personnel were terminated or ceased working with the office. Were you aware of that?
The question has been asked and answered already.
That was part of the cross-examination, Mr. Cadman.
Oh.
And I think the answer was that she was aware of people leaving, and she also dated the time it occurred.
Your Honour, if I can just confer one moment on that point.
Yes, you may.
We may need to come back to that point, but I just want to return for a moment You've said today that your instructions were not merely oral, they were in writing and via email. That's your evidence today.
That is correct, yes.
But if we go to the transcript of the 20th of October, at page 1066, you say completely the opposite, that there were no written instructions, that your instructions from Ms. Bellici were orally.
I don't recall saying that there were no written instructions. I believe I remembered oral instructions, but thinking of it deeper in session, I want to confirm I remember receiving also written instructions, a couple of emails, I believe. It's all on the record.
But if we can turn to page 1066 of the transcript, looking at line 8, you said, the question was put to you, did you send an email back to the person confirming informally what you had been asked to do? Not that I recall. Is that usual operating procedure for the SPO? Yes, it is. So the normal operating procedure within the SPO is that you would be tasked to undertake actions verbally without any record being kept of what you're asked to do. That is correct, yes.
Your Honor, for completeness, I would also ask the Council to refer to page 168 of the same transcript, where the same subject was considered again and clarified by the witness. I refer to the lines 5 to 13 of page 1068. I can read it if...
You can certainly raise that on redirect, but right now
Yeah.
your position is overruled.
I want to go back for a moment to your role in the investigation. What you have said is that you were instructed to conduct a review of the material, of the 3 batches, and make a determination of whether that material was within your database. That's what you were asked to do.
Not only. As you can see from the declaration, there are a number of issues I reported on.
We'll get
Not
to
only that.
We'll get to those in a moment, but principally you were asked to review those 3 batches. And when you were asked whether you went further, conducted additional analysis, you repeatedly stated that no, that's not what I was instructed to do.
I did not conduct any analysis other than the one which I was tasked to do. That is my statement.
And from the 25th of September, I just want to look at what happened after that point in terms of the investigation. So you've been made aware of what is, by all accounts, a significant security breach. And as an experienced investigator, and we've heard about your experience, would you agree that any investigation must consider all the facts, follow leads, and follow the evidence to ensure what is established? Would you agree with that?
When you say would follow all the leads, I mean, these are hypothetical now. It's like you have to consider your entire operation and you need to prioritize. So there are internal and external factors who will play a role whether you follow every lead, e.g. personnel issues or security issues will have an impact on how you progress an investigation or a lead.
You said when you were presented with a hypothetical situation that you probably would have ordered surveillance, but that wasn't your responsibility.
I believe, and I hope I said that I would take it into consideration as an option.
And after the 25th, you did not order any surveillance of the premises.
I had no involvement in that decision-making process.
And despite the request being made by the association, no discussion was taken to place the premises under surveillance.
Your Honor, is not in evidence about any request made by the association.
Well, let me rephrase the question.
You may rephrase the question.
Were you made aware of any request by the association or the defendants to place the premises under surveillance?
No, I was not.
You've also confirmed to us that part of your responsibilities in other matters is the interviewing of witnesses and suspects. That falls within your remit on a general level.
I also interview suspects and witnesses, yes.
But you didn't interview either Mr. Haradinaj or Mr. Gucati.
I was not assigned this task, yeah, correct.
You didn't interview any person at the KLA War Veterans Association.
I had no involvement in that, that is correct.
You didn't interview any person in the building of the War Veterans Association.
No, I did not.
And as far as you're aware, no other member of your team did.
I don't know what they did because I was not part of the investigation.
So from the 25th of September onwards, you were never made aware of any action that was taken as part of the investigation?
I was made aware in the sense that I reviewed the badges and the official notes. So as I was reading, I got more and more aware of what has taken place. But from an operational level, when things took place, I had no knowledge and no involvement.
So neither did you interview any of the journalists present at either of the press conferences?
I was involved in the interviews of, I think, 3 journalists.
You didn't have cause to question Mr. Asim Lani or Ms. El Medina Balaji?
I don't remember the names now.
Directly opposite the building, there are a number of businesses that all have CCTV pointing towards the building which houses the KLA War Veterans Association. You didn't have cause to interview any of those or try to secure the CCTV material from either of those 3 days?
You mean me personally? I was not involved in the investigation. I had no involvement in that.
To the best of your knowledge, did any of the investigators conduct any interviews with any of these individuals?
I am not aware of that.
And we've also heard, and you can confirm, you had no direct contact with the Kosovo police as part of this investigation.
If we can just distinguish between 2 things, is my involvement in the search, there were Kosovo police there, and I don't know, have I spoken to them, but they were part of the team. In relation to what I think you are referring to, investigative steps, investigating the disclosure of the badges, is that what you are asking me?
My question was, other than the Kosovo police being outside of the building, you had no contact with them as part of your investigation, as part of your role in this investigation?
My role in the search, you mean?
Well, I'm talking overall as part of your responsibilities from the 25th of September onwards.
I was not involved in investigations other than speaking to the journalists, so no, I don't think I spoke to any Kosovo police officers.
So who would have had responsibility for that?
As I mentioned before, the overall responsibility of conducting this, directing this investigation was with the specialist prosecutor and the deputy. They have tasked individuals to conduct investigative steps.
And following your engagement at some point before the 25th, at no stage were you asked to complete or create a work plan for the investigation?
Your Honor, I think this question has been asked and answered several times now.
Overruled. You can answer that question.
I did not have involvement in the investigation before.
And is it your evidence that you had no involvement either into the investigation into how the material was leaked?
I had no involvement in this investigation. excuse me, with the exception of the search where we looked for material, just to be precise in case you're looking for this.
And looking at the search on which we've all had the opportunity to see on the 25th of September, that entire search was video recorded. That's correct.
That is correct.
And to the best of your knowledge, no such video recording exists for the operations on the 8th, the 17th, and the 22nd.
I'm not aware.
Did you not ask?
Like I said, I did not make inquiries. I was tasked specific jobs to do, and that is what I did. In line of performing this task, I did not get aware that there is any video recording.
So you didn't become aware. My question was, did you not ask after the 25th of September for a copy of the video recordings of the 8th, 17th, and 22nd?
As I said, I'm not aware that there were any video recordings, and I didn't ask whether they didn't ask for them, as I wasn't aware of them.
You didn't ask for them. Now, going to what you were asked to do, to review what was presented to you as the three batches, and we've confirmed that you had no involvement in the seizure of that material on the 8th, 17th, and 22nd. Correct?
Correct.
And as you've said in each of the three batches, and perhaps we can turn to them after the break, the only record, or the record that you were presented with at that time, were the three handover forms that Mr. Rees took you through in cross-examination.
Not only the free handover forms. If
You've said that the three handover forms were the front pages for each of those batches that you received.
that is correct.
Your Honours, I think I'll come back to that point after lunch. I want to just check the references before I come back to it.
Mr. Rees, I assume you mean you're going to check the references but at this next break.
Yes.
Okay, that's not lunch.
No, that wasn't a question. Effectively, there are two additional points that I want to put to the witness.
No problem. I'm just trying to get the timeline straight.
Certainly. And certainly I will be done by the lunch break. It's not a particularly long point that needs to be put to the witness. I just want to get in order the transcripts from the press conferences and the handover notes. So perhaps if we could break 10 minutes early, I can take those points now.
sorry, I thought I had it on. We will break now, come back at 20 minutes after 11, and then proceed on until the lunch break. Thank you, Ms. Pumper.
All right. All rise.
Be seated. Go ahead, Mr. Oh, well, we need a witness. Please bring the witness in. Mr. Cadman will continue with his cross-examination.
Your Honor, I just would like to note for the record the case and evidence manager is not present at the moment. I believe she will be here shortly.
Okay. Thank you.
I just want to start by looking at the point that we dealt with at page 33, line 23 of today's session, where the presiding judge said that was part of the cross-examination, Mr. Cadman, and I think the answer was that she was aware of people leaving, and she also dated the time it occurred. If I could just correct that, if I may. If we turn to the transcript of the 21st of October, at page 1249, line 16 onwards, Mr. Rees asked, can you confirm that in the period of 22nd of September and December 2020, there were some 25 staff members, including 4 team leaders, whose time at the SBO came to an end? Answer, no, I cannot confirm that. Question, without the numbers, can you confirm that there was, well, are you aware of any staff members whose time at the SBO came to an end during that period? Ms. Bellici then objected. Your Honour asked what was the relevance, and then at page 1250, line 14 onwards, Mr. E said, yes, the last question hasn't answered. Are you aware of any staff members whose time at the SBO came to an end during that time period, which was between the period between 22nd September, December?
The interpreters kindly ask the speaker to read slowly when quoting. It's impossible to interpret at this speed. Thank you very much.
I do apologise, Your Honour.
Yeah.
I can read the last question again. Are you aware of any staff members whose time at the SPO came to an end during that period, which was the period between 22nd of September and December 2020? Answer, I don't recall whether anyone specifically left at that time. That was her answer. So, just to, if I can boldly correct what Your Honour said earlier, she did answer the question and said that she was not aware. Now, I'd like to go back to a number of questions that we spoke about earlier. That's today's. That's what she said. That's what she said today. So, today, you said, all until I started working for the SBO, my experience did not involve any case going in the trial phase. My experience is investigating until indictment, and then I move on to the next case. That's what you said today. Then, if we can look at the transcript of the 20th of October 2021, page 1151, you were asked by Mr. Rees if you've previously given evidence at trial before, and you said that you have. So your answer earlier is not correct. You've been a witness in a trial previously. So which one is it?
If you allow me, what I said today is I meant as an investigator doing my job as an investigator. I was never involved in the trial phase before joining this office. But I have testified as a witness in trial before.
Now, you also said that you were not aware of the disclosure obligations earlier today because of the fact that you've not been involved with the trial phase. But you must understand that those disclosure obligations are relevant from day one. Are they not?
I think that I have said, when I was asked the first time, that if I came across exculpatory evidence, that I would, of course, report it to the prosecutor immediately. This is what I would do as an investigator investigating a case. I have, I think, also said that in this office we have a whole team dealing with disclosure, and that I've been involved in exculpatory review. So please excuse me, I just don't know the exact ins and outs that you want me to answer.
So you are now aware that there are members of your team that are responsible for disclosure?
I think I've said that the last time you asked me that there is that we do exculpatory review.
Now, what I want to look at, if we can, is a transcript from the first press conference, which is 081344-01-TR-ET. Now, if we look at page 2, lines 15 to 17, here you see Mr. Haradinaj criticising members of Parliament and making reference to what he considers to be a mono-ethnic court.
Excuse me, which paragraph are you at?
It's lines 15 to 17 of page 2.
I don't have numberings of lines in front of me.
Do we not?
The exhibit doesn't appear to have numbers.
Your Honor, for the record, that is Exhibit P1 admitted.
If I could just take a moment just to check the reference. It may be that the reference is not correct. It does appear that the reference from the document I'm looking at, which comes as disclosure 2, I'm going to have to check what the actual reference is on the presentation queue, because it may be that I'm using what has been disclosed but is not the same reference in presentation queue.
Are you going to go on to a different subject then? Is that it?
I apologise, Your
Are
Honour.
you going to go on to a different subject then?
Well, Your Honour, I think I'm just going to have to, just for a brief moment, check.
Oh, okay.
Because there are a number of references that need to come out of this.
All right, I just didn't understand your point.
whilst we're checking those, I'll move on to another subject and we can come back to that.
Thank you.
Now, earlier this morning, you referred to a meeting that took place, an office-wide meeting at some point after the 7th. Can you tell us when that meeting took place, approximately?
What I was referring to is a meeting which took place month after the 7th.
A month after 7th?
Months, T-S, several months after that.
So there was, after the press conference on the 7th of September, on the 7th of September, there was no office-wide meeting immediately afterwards.
What I'm saying is that I recall one which took place months after, where the specialist prosecutor spoke to the entire team. I'm not saying one didn't take place before.
So you're not aware of any meeting that took place after the 7th?
I can only repeat, it has been a year ago. I don't recall.
You don't recall any meeting occurring after the 17th, after the second press conference?
I can't recall any meeting.
No meeting took place after the 22nd?
I'm not saying that no meeting took place. What I'm saying, it has been a year and I really don't remember. I can't confirm in the positive, neither in the negative.
And you were not part of any meeting, if a meeting did take place?
I'm not sure whether it's my English. I can't recall whether a meeting took place.
And when you were instructed to do the task that you were instructed to do, there was no briefing after the 25th in relation to the matters that had occurred.
Would you please, if you
so
would just allow me, when you say a briefing, what do you mean with that?
Well, a briefing on what had occurred, that there is a suggestion that there has been a major security breach of data held by the Special Prosecutor's Office, and you were not informed until, as you say, months later.
As I said, I have become aware sometime after the 7th of the first disclosure. Just don't remember when after the 7th. I do not recall, I simply don't remember. I'm not saying it didn't take place or it took place, that there was an official meeting where the entire office was addressed about the matter. That is my position.
But surely you would remember if a meeting took place dealing with what is effectively, internally, a catastrophic event. Would you not?
I can only say I don't remember.
And you don't remember any meeting after the second press conference either?
I think I've answered
I think
that.
it's been asked and answered about 10 times by now. I would suggest that we move on to the next line of questioning.
You can answer the question after the second meeting.
Microphone, please.
I overrule your objection. You may answer about after the second meeting.
Is the same answer as the first meeting, first press conference. I really don't remember. It has been a long time.
And your answer would be the same after the third press conference on the 22nd?
That is correct.
And after you conducted the search on the 25th, was there any meeting at any time, or was there any meeting around that time internally dealing with these matters?
I think what I need to say, we have a Friday weekly meeting. It's just that I don't remember was anything mentioned on that Friday weekly meeting. I would be assuming something.
I think she's been quite clear about this. Let's move on.
So, just one final question on this point. So, at your Friday weekly briefings, are they chaired by the Specialist Prosecutor?
Your Honor, there is an objection about the relevance of the specifics of the internal working procedures.
I understand your objection. It is probably peripherally relevant, and I'll allow the answer, but then you said one more, so that will be it.
Generally speaking, the specialist prosecutor is not in attendance to these meetings.
But you have...
Sorry, I have to clarify. I'm not sure whether he's in attendance because it is over Teams. He doesn't speak during these meetings.
And so between the 7th and the 25th, you would have had 3 Friday team meetings.
If they had not been cancelled, I suppose so.
Do you remember if they were cancelled?
I don't recall. It's been a year.
Well, are there minutes sent around as a result of these meetings? Or are these just oral presentations?
These are oral presentations, and I do not know whether the assistant to the management takes minutes.
You certainly don't receive any minutes after those meetings then?
I have not received minutes for these meetings, no.
You said that you became aware of the first press conference after the 7th. Do you recall when that was?
I cannot recall.
Within a day?
As I said, I think I can't tell. It's the day later, a couple of days later.
Do you recall how you became aware?
I cannot.
You also spoke earlier about security measures that were put in place as a result of what transpired from the 3 press conferences. What security measures were put in place?
Your Honor, about the questioning into the internal security protocols of the office.
Microphone, please.
Where you're going with this, we don't see very much relevance. It also has to do with internal working arrangements. You're going to have to be very careful and state the case that you have so that we know the direction you're going in and we can judge it accordingly.
Certainly. The point being made, as the witness has said earlier today, that there were security measures put in place as a result of the breach. I'm merely trying to identify what measures were taken and when those measures were taken.
You're not satisfied that security measures were taken. You want to know exactly what? Isn't that a little bit into an investigation that you're not privy to? I think I'll sustain your objection based upon that statement of the case. You do not need to answer that question. Go ahead.
So, not answering what measures were put in place, can you tell the court when those security measures were changed?
I don't remember.
At any stage after the 7th, were you briefed by security personnel within the prosecutor's office as to what those security measures were going to be?
To my recollection, we received an email.
You received an email. Can you expand upon that?
Sorry, in relation to your question, I was not briefed of security personnel. I received an email.
You received an email. And that was the extent of the security notification that you had?
To my recollection, yes, we received a detailed email. Yeah.
just want to go back for a moment on the question of disclosure. Now, and I'll try not to repeat what I said earlier, but you recognize that from the outset of an investigation, it is your responsibility as an investigator to review any information that undermines the prosecution case or supports the defense case. You understand that?
I do.
And that there is an obligation on you to report that to your disclosure officer. Or to report that to the prosecutor, if that's who you're reporting to.
As I mentioned before, yes, we have in this office a system in place how we address this specific issue. And before that, when I came across exculpatory information, I've reported it to prosecutor. That's what we do in Austria.
Okay. That's what you do in Austria?
Well, I am a police officer from Austria. My police education was there, and that is a principle which we were taught.
So you understand that as an obligation on you as an investigator within the SBO?
I don't know whether it is an obligation on me as an investigator. It's an obligation of the office, yes.
Of the entire team?
Well, of the office. Now, please don't hold me to.
Of which you are a member?
I'm not saying I'm excluded.
So you accept that there is an obligation on you in conducting an investigation to disclose potential material that undermines the prosecution case or could potentially support a defense raised by a defendant?
I think that I'm part of an office which has processes in place which would fulfill this obligation. I haven't read that anywhere it's written that I specifically have to do it. I think that's where we are discussing, sort of.
Now, you said that you reviewed the transcripts of the 3 press conferences as part of your as part of your involvement in this matter.
I read them, yes.
And I believe we're still having difficulty identifying where they are, so I will try to. They're fine? Apparently, the files that we have has a line numbered system, and what's in your system does not have a line number. I believe that's the issue. But we believe that we can actually track where they are, so I can inform. So, turning to the first press conference, looking at my page 2, lines 15 to 17. Sorry, page 2, lines 15 to 17. Your version is page 2, line 2. You'll see there.
Excuse me. Would you please shrink the page that I can see the whole page? Thank you.
Do you have that?
I have the page. Would you please point me to which line?
Line 2. You'll see here that Mr. Haradinaj is making reference to members of Parliament and referring to what he considers to be a mono-ethnic court.
Yes, I can see that.
Then if we go further down, lines 21 to 23, line 4, you'll see he refers to cooperation with the Milosevic state apparatus.
I can see that, yes.
Line 8, you'll see that he only flicked through the documents. Same page, paragraph 3, line 1. He makes the same reference. Next one. Page 2, paragraph 5, he again makes reference to the Milosevic regime, referring to Serbian officials who are responsible for atrocities in Kosovo. Final paragraph, page 2, he calls for accountability and then accuses the SBO of having collaborated with those who tortured and killed Kosovo Albanians. Next page, line 1.
Mr. Cadman, is there a question here, or are you just making statements?
Well, I'm taking her through these points because it's quite clear from these points.
And my question is there a question here?
There
That's
is
what a witness is here for.
Certainly. When you reviewed these transcripts, taking into account some of the references that I've already made, what steps did you take?
Sorry, when
The point being made is that you can see from these references, and following on from the point that we've made as your obligation, what steps did you take to raise these with whoever you were reporting to at that time as matters that undermined the prosecution case or supported a potential defense case?
I reviewed this transcript, and my task was to identify the names, I think they're on page 1, specific names, which were mentioned, I believe you said Mr. Haradinaj, by Mr. Haradinaj, and to check whether these names are contained in the batch. My job was not to review this and report back on the contents of it. And I have received this document from the prosecutor, Ms. Bolici.
So you didn't consider it to be your task to do anything other than to review what names had been stated by Mr. Haradinaj?
The specific task which I was given here is to review, to check these names, and that is what I did, but I read the entire document.
One final reference that I would like to make is page 3. It's the paragraph that starts, "I believe it was necessary."
I've read it, yes.
Okay. Now, as you can see, what Mr. Haradinaj is stating there is that he considers that he did this in the public interest. This is not a matter that you took upon yourself to review?
I think
Apologies. There is another objection. The question has been asked, has been answered. The witness clarified the scope of her task, and the question is argumentative.
I'll overrule the objection. The question has been asked many times. I'll let you ask it this one more time, then we're finished with that.
So you didn't consider that to be a relevant consideration in your review?
my task was not to identify the relevance of all the details in this document. My task was to view specific names and to cross-check those.
Mr. Cadman, I've been reminded that this is P1. You need to make reference to it as P1 so that the record will show where you're getting these statements.
I'm grateful, Your Honor. I just have one final question. We will need to go into private session for that.
I'm sorry. On the record, into private session, Ms. Court Officer.
Mr. Rees has indicated there may be a need to recall this witness later on.
For the record, Your Honors, we're in public session.
We're back in public session. Could you make that statement again on the public record?
Oh, I do apologize.
No, could you make your statement again?
We're in public session now?
Yes.
I have no further questions for the witness at this stage. As Mr. Rees has already indicated, we may need to recall this witness at a later time.
Madam Prosecutor, do you have any redirect?
Just a few questions, Your Honor.
All right. As you know, the SPO may be permitted to conduct a redirect examination, but only on matters arising in the cross-examination.
Yes.
This is what we've said in our paragraph 76 of our order on the conduct of proceedings. Can you please state the reasons for your redirect?
Yes. There were some questions put in the course of the cross-examination in relation to the confidentiality of the documents in the batches. The witness provided some answers in relation to that. I would like just some clarifications in relation to this topic.
You may go ahead.
Thank you. Investigator, you mentioned in the course of the cross-examination that you verified whether the coordination requests in batch 1 are contained in the SPO evidentiary database. Is this correct?
That's correct.
And are they contained in the SPO evidentiary database?
They are.
And are the coordination requests contained in batch 1 part of the SPO, SITF or SPO investigative records?
Sorry, would you please repeat this question?
Yes. Coordination requests, in general, requests for assistance in criminal matters, are they part of the investigations or the SITF or SPO?
Yes, they are.
Okay. And do these coordination requests pertain to SITF or SPO investigations?
Yes, they do.
And based on your experience as an SITF and SPO investigators, are records of investigation confidential?
Yes, they are.
Thank you. In relation to batch 3, you were asked some questions about the confidentiality of that document. And I would like to ask, does batch 3 pertain to SPO's investigation?
Yes, it does.
And does this document contain information that, to your knowledge, had not been made public by the SPO?
To my knowledge, it has not been made public.
Okay. And did include names of witnesses that the SPO had interviewed?
Yes.
And did include references to information and evidence provided by that witnesses?
Yes, it did.
And to your knowledge, did the SPO ever made public any name or evidence of information provided by witnesses to the SPO?
To my knowledge, they did not.
That would conclude the re-examination, Your Honor. Thank you.
Thank you, Madam Prosecutor. The panel will now have some questions for you, Ms. Pumper. We're getting close to the end.
Thank you.
Judge Mitro has some questions. You have the floor.
Thank you, Judge Smith, and good morning, Ms. Pumper. I'd like to ask you first about the potential indicators of confidentiality that you have identified in your declarations and its annexes. And you will recall that on the 20th of October, you were asked by Mr. Rees about some of these indicators, and Mr. Rees made the point a number of times that the document, the batches, to use that term that you used, went into the hundreds of pages. Do you recall this questioning from Mr. Rees?
Yes.
Well, what I want to ask you is this then. If we were to replicate your review of those batches, how often, if you can tell, would these indicators of confidentiality appear in these documents? Was it every page, every other page, every document? Are you able to tell us how common and frequent they were in your review of these batches?
Your Honor, when you look at the spreadsheet which I made, there I list every single document, and I also have a column which states how many pages this document is. So you would see there that, for instance, document 1 contained of 2 pages has 4 indicia of confidentiality. So if you go through this spreadsheet, it will answer this question, I believe, for each of the documents.
Thank you. And one of the indicators of or potential indicator of confidentiality that you identified and that you discussed briefly with Mr. Rees was the presence on some of these documents of the SITF logo. Now, what I want to ask you is why you considered the presence of this logo to be of potential relevance to determining the confidential status of a document.
When I reviewed this, I thought of indicators suggesting confidentiality. So SITF is an institution investigating crimes committed at a certain period of time. And for me, the institution itself could be an indicator to a reader that it could be containing confidential information.
And did you consider it as such on its own as a potential indicator of confidentiality, or in combination with other factors that you identified in some or all of these documents?
Your Honor, I believe you will see from the spreadsheet, I don't think I have I don't think I've come across one single document that only contains the SITF logo as an indicia. It was multiple indicators.
Now, there's a related but slightly different issue that was explored by counsel with you, and it's the question of cooperation with third party, SITF and SPO cooperation with third party. And you were asked in particular by Mr. Rees about cover letters accompanying these requests for assistance, these cooperation requests. Do you recall being asked about that?
I do.
Now, can you tell us whether, as a matter of practice, the content or the tenor of these coordination requests was treated by SITF and the SPO as confidential? And if so, why?
As I mentioned, I have not been a long time with the SITF, so I don't have too much personal experience, but what I have seen and what I inquired is, for instance, these coordination requests were sometimes sent in encrypted form, electronically, to this institution. Then these coordination requests, they contain names of witnesses. So also the cover letters sometimes, they contain, we want to meet with A and B, could you please summon these individuals?
Does that mean that, and again to your knowledge of course, these requests and the responses to the requests were treated by your office as confidential? Is that a correct understanding?
That would be my understanding, yes, clearly.
Now, you also asked about a number of media reports that contain documents identical or potentially identical to those recovered from the KLA-VWA. And I want to ask you a couple of questions about this. The first one is whether you are aware, whether you have any indication that at the relevant time, meaning September of 2020, there was another source of the same information that could have provided these documents to the media. In other words, whether you came across information that could suggest that these journalists, this media, could have obtained the same information from another source.
No, I did not.
And staying with these media reports, can you recall approximately how many of these made express reference to the origin of the material that they were using in relation, of course, to these events? In other words, can you recall how many articles, what proportion of the article expressly mentioned the fact that they had received the published information from the KLA-VWA?
Your Honor, just for the purpose of precision, I believe that to a previous question, to be accurate, I believe that there was the Gazzetta, one outlet made a reference that they obtained the document from the SBO. Just that is sort of a different, something what I read. And to your second question, I have no knowledge.
Now, I want to go to something slightly different, Ms. Pumper. On the 25th of October, Mr. Rees asked you about a number of individuals, witnesses or potential witnesses, who are said to have disclosed their status as witnesses. Do you recall these questions?
I do.
And Mr. Rees asked you about a specific individual, and I want to ask you about this. So I will go to an exhibit, Ms. Pumper, and I will ask you not to use the name, but just to look at your declaration. This is exhibit P86 MFI. This is your declaration of the 29th of October 2020. It's ERN 084015. And I will ask the registry to go to page 6, please. It's ERN 084020. And to focus your attention, Ms. Pumper, on paragraph 31. Now, do you recall being asked about the individual, asked actually by counsel for both sides, about this specific individual mentioned in paragraph 31 of your statement? Do you recall that?
I do.
Now, we understand the prosecution's case to be that one of the accused disclosed that name in public as part of one of the press conferences that were held. Now, I want to ask you, and again, of course, if it is within your knowledge, would you know why this particular individual might have attracted the attention of the accused? Any information specific about him that you think might have or might go to explain why his name, rather than the name of the many other witnesses you identified, might have been mentioned by one of the accused?
I do not know, Your Honor.
Now, you've been asked also about the presence or absence of ERNs, the numbering system on documents. And if I've understood your evidence properly, you've indicated that some of the documents that you retrieved from the VWA were effectively in substance the same as those in your records, but some of them did not bear an ERN number. Is that correct?
The documents which we have seized, they do not bear a ERN number.
And what, if anything, could you conclude from this in respect of the potential origin of the leak? Is there any information, any conclusion that you could draw about the presence or absence of the ERN from these documents?
I would be speculating.
And I won't ask you that, Ms. Pumper, but I will ask you about another document which Mr. Rees asked you about on the 21st of October of 2001. It's a document that came from the Serbian authorities, and you've indicated that you were not able to retrieve that particular document from the records of your office. Do you recall?
Correct.
And again, same question, and please tell us if you can't say anything about it, but what, if anything, would that potentially indicate in terms of the origin of the leak, the fact that you were not able to retrieve this particular document from the record of your office?
Again, I believe I would be speculating.
So I'll spare you the speculation, Ms.
Thank you.
Pumper, and I'm grateful for your answers.
Ms. Pumper, I have a couple of questions for you on your evidence which you've given. You told us this morning that you were an investigations operations leader at the SPO. Do you recall that evidence?
I do.
Now, on the basis of your experience in the SITF and subsequently with the SPO, do you have any reason to believe that any current or former member of the SPO was involved in any way in providing any of the information contained in the batches of information to the KLA War Veterans Association?
I have no information that this took place.
Do you have any reason to believe that any person acting under the instructions or control of the SPO provided any of that information to the KLA War Veterans Association?
I have no information to that effect.
To the best of your knowledge, did the SPO carry out any steps to rule out the involvement of any current or former members of the SPO, or any person acting under the instruction or control of the SPO in the delivery of information to the KLA War Veterans Association?
Your Honor, respectfully, I have no information of the substance of the investigation into this matter, so I cannot answer what was investigated or what was not investigated. I'm not privy to this information.
Thank you, Ms. Pumper. Thank you, Mr. President. No further questions from me.
Yes, thank you, Mr. President. Good morning, Ms. Pumper.
Good morning.
I have also a few questions in relation to the search and seizure carried out by you and your colleagues at the office of the KLA-WVA on the 25th of September 2020. And I would like to ask Madam Court Officer to put for us on the screen ERN range 083-846 to 083-927. I don't think it has a P number yet. Thank you very much. Ms. Pumper, first, I would like to ask you how many of your colleagues were involved in the search and seizure operation on that day? Or in other words, how many people from the SPO participated in the operation, including yourself?
Your Honor, I don't remember the exact number, but can I say maybe 7 to 10?
Thank you. Could I ask Madam Court Officer to put for us on the screen page 083894?
Your Honour, can I ask if this is in the list of exhibits that have been indicated that this witness would address?
It is not on the list. No, it is not.
Well, I do understand, of course, that the trial panel is entitled to, if I just get the words right in the rules, invite the submission of additional evidence not produced by the parties where it considers it necessary for the determination of the truth. That's Rule 132.
Yes.
That is, of course, after hearing from the parties. And we've had no notice, of course, in relation to this.
We will go ahead with Judge Barta's questions. We will reserve some time for you to ask any questions about that afterwards.
Oh.
Thank you. So, Ms. Pumper, unfortunately, there is a black box right beneath your name on this page. But just to, or in order to refresh your memory, can you, I don't expect this is secret information, can you say, or can you be more precise in relation to the question? I asked if you know how many people were involved in that, on that particular day.
Just one moment. Myself plus 8.
So 9 people, all in all, including yourself.
That is correct.
Thank you.
And if I can just be precise, for instance, we had security personnel and special units. They are not included here, but they are for security purposes only, don't participate in the search per se.
Thank you. And I think you said earlier this morning that the Kosovo police were also present during the search operation. Is that correct? Not in the building, but maybe outside the premises?
Yes, I believe they had the second or third parameter of security. I'm not sure, but I know they were there.
Ms. Pumper, my next question would be, how long did the entire operation take, and how many rooms, if you can remember that, how many rooms were searched on that day?
Your Honor, I would refer to this report, which states exactly the start date, time, and here the finish time is 1921. And I can confirm that there were 2 floors with several rooms, but I can't remember now the rooms.
Thank you. Maybe I can ask Madam Court Officer to put on the screen page 083887. Ms. Pumper, you can, I assume you can read on the top of the page the starting time of that operation.
It's 14:02.
Thank you. There was, Ms. Pumper, if I remember correctly, a sequence in the video we saw yesterday in which you I believe it was you, who stated that someone from the KLAWVA broke a door during the execution of the search warrant or the search warrants. Could you give us more details about this? Who broke the door and why, if you know?
Who broke the door was Mr. Faton Klinaku. And the sequence of events was that when we were at the locked door, he did ask me, rather relaxed, shall I break it? And I said, no, don't break it. We will try to obtain a key. And I turned around and he broke it.
But you can't say why.
No idea.
Right. My next question is, were there, Ms. Pumper, any security concerns that had to be taken into consideration in general in the planning of that operation? From your office, from you as the executing officer in charge?
There were security concerns which had to be taken into consideration. What concerned me specifically as the coordinator of the search is that I needed to take into consideration what may happen outside and which may have an impact on the time, how long we have to conduct this search at this rather large location.
So were there specific or just general security concerns? I mean, specific in relation to that specific operation on that day?
If my memory serves me correct, it is that there was an expectation that there would be large crowds potentially gathering at the War Veteran Association, considering whom they are representing.
Let me put it in other words. Just generally speaking, how would you describe the situation for an SPO officer who executes or intends to execute a search warrant against former members of the KLA or members of the KLA WVA in general? Is it dangerous, or is it, for you, is it business as usual?
In relation to the question whether it's dangerous, I think our security sections is the right place to answer that respectfully. For me, I don't have security concerns. People are taking care of my security. What my concern is that security is a concern, so I have to take this into consideration. For instance, how fast I move, how I do this, and how I go about a search.
And this is what you did in that case?
This is what I did, yes.
I also think you mentioned earlier this morning that there were security guidelines, and I assume also specific security or safety procedures or rules in place for the execution of search warrants. Is that correct?
That's correct.
And are you in a position to say that, or to confirm that these security guidelines or procedures and rules were observed by you and, as far as you know, by your colleagues on that day during the operation on the 25th of September 2020?
What I have seen and what I have witnessed, I can confirm that in the positive.
Ms. Pumper, how would you describe the atmosphere during the aforementioned operation compared to other search and seizure operations you conducted in the past, be it with the SPO or the SITF or other Austrian authorities or other authorities in general?
If you just give me a moment. For me as a professional, coordinating this search at the War Veteran Association, it was a big project. It was very demanding. It was a big building. It was a big case. It was the first search. So yes, it was, if I can put it so bluntly, a big deal.
Thank you. And next question. I take it from the video we saw yesterday that Mr. Tomogashi was also present during at least parts of the search. Is that correct?
To my recollection, he was present during the entire search.
Can you say in what function was he there on that day?
Mr. Gashi was appointed the legal representative of the War Veteran Association to be present during the search, which is a legal requirement.
Was what we call an independent observer present during the search and seizure operation?
Yes, there was.
And Ms. Pumper, has anybody Anybody complained about the way the search warrant or search warrants were executed? For example, Mr. Gashi as the legal representative, or someone from the KLA-WVA, or even the independent observer?
Your Honor, if you will indulge me, I would like to make 2 comments to that.
Please, go ahead.
So, I would like to state that Mr. Klinaku, he was the representative of the War Veteran Association in the absence of Mr. Gucati, and he made a point of telling me personally that I conducted myself and the search very well. And Mr. Tom Gashi, who was the legal representative for the War Veteran Association, at one point even told me, stop making such a fuss. You know, we know you're doing this correctly, but that I'm overdoing it. And I responded to him, this is a search, this needs to be done squeaky clean to the legal requirements, and this is how we progressed. So I would be very surprised if we heard otherwise.
Thank you. Could I, Madam Court Officer, ask you to put on the screen for us the document under 083919, excuse me, I repeat, 083901.
Would you please make it smaller, that it fits the page?
Can you see it, Ms. Pumper?
Yes, I can see it.
Is that what you just referred to?
No, that was not what I referred to.
But can you remember Mr. Klinako making such a comment?
I remember Mr. Klinaku stating this straight away when he came to the War Veteran Association, and actually the same was reiterated by Mr. Gashi. And I addressed this issue straight away.
Thank you. Madam Court Officer, could you go to the previous page, please? Thank you. Ms. Pumper, there you can see, I guess, a comment made by the independent observer. Is that correct?
That is correct.
Could you read this comment, please, for the record?
No comments or concerns. The process was conducted very professionally.
Is this what the independent observer wrote in your presence on this document?
That is correct.
Thank you. Ms. Pumper, did you or one of your colleagues, as far as you know, write a report about the search and seizure in addition to the video recording? And if so, how many? And which reports were prepared by you or by others?
Your
Can you
Honor,
say that?
Yeah, the only report which was produced is this report which you are showing me now. There are no other additional reports. I consolidated the information and placed it in this report.
So this is the only report you wrote, actually, after the search and seizure operation? Or may I ask, Madam Court Officer, could you go back to page or ERN 083846? So the first page in this ERN range. And could you scroll down to the next page, please? referring to paragraphs 8 to 10. Ms. Pumper, could you again tell us how many reports were, not only by yourself, but also by other colleagues in the SPO prepared or drafted?
I apologize, Your Honor. When I mean the report is, I mean this report, which I consolidated all the other reports and exhibited to it, yes. So
is it correct that there was a report, what is called supplement report? Oh no, I'm sorry. Let me refer to paragraph 8, a report on search of persons, premises, and or other property outlining the sequence of the events of the search, and also another report, under paragraph 9, mentioned in paragraph 9, a supplement report to the report on search and persons, and additionally, referring to paragraph 10, it is stated the SPO compiled a photo report on seized evidence containing pictures and detailed explanations related to the 7 pieces of evidence, and so on. Is that correct? So
that is correct, yes.
Survey reports
Yes.
were prepared.
Yeah, sorry.
And written. Thank you. My last question would be, if I remember correctly, Ms. Pumper, you mentioned yesterday that you had to be, and I think you used the term inclusive. Can you remember that?
Yes, I do.
Could you explain what you mean by that term?
If you indulge me to give just a bit background. Mr. Gucati has decided that Mr. Fatou Klinakou would be the representative of the War Veteran Association. There was quite a heated situation and a lot of heated discussions until we finally managed to settle and get on with the job. And something which I always kept in mind is that, you see, Your Honor, I can only conduct this search if I have cooperator, if Mr. Klinakou cooperates. If he's out of shape, I need then to find another representative because he won't be able to concentrate on the search, which is his task to observe. So for me, I could tell that he was irritated about us being there, which I consider very natural. So I tried to do the search in a way which was highly respectful and accommodating this a nuisance that he is annoyed with us being there. And part of it was that I allowed him to be maybe closer to the officers and monitoring the search closer than maybe I would have done in other situations.
I understand. Those were my questions. Thank you, Ms. Pumper.
You're welcome. Thank you.
This document was obviously used to refresh the witness's memory on 3 items. The number of the team members that were involved in the search, the time of the search began, and some other peripheral items. You can ask questions about those, but please not into great detail.
No, I follow. Thank you. Just, I think very briefly, firstly, in relation to the independent observer, was the independent observer briefed before the search about the issues in the case?
Sorry, do you mean facts of the investigation?
Was the observer briefed about the issues in the case?
I don't understand what you mean with issues. I apologize.
I'll be specific. Was the independent observer specifically briefed that one of the issues that had been raised by Mr. Husni Gudzati repeatedly, we went through the references in the transcripts of the press conferences, TV interviews, one of the issues being whether the source for the information was indeed the SPO itself? Was the independent observer briefed about that being an issue before the search?
No, she was not.
No. Mr. Fatou Klinakou, are you aware as to whether Mr. Klinakou has any experience whatsoever in the conduct of police searches?
I'm not aware.
No. You would regard yourself as being somebody with experience of the conduct of police searches rather than Mr. Klinakou, would you not?
Mr. Klinakou was appointed by Mr. Guzzati. I don't know as why he chose him.
Mr. Klinakou, of course, as far as the SPO is concerned, was a suspect in the case. Was he not?
I had no knowledge of that at the time when I conducted the search.
Again, it didn't form part of your appreciation of the facts that the SPO regarded Mr. Klinakou and Mr. Tom Gashi as suspects in the case. Is that right?
I have no idea when Mr. Klinakou was regarded a suspect in the case.
Thank you. No further questions.
Thank you.
Nothing to add.
All right. We are finished with your testimony, and you will be escorted from the courtroom. We thank you for your attention and your candor, and wish you well.
Thank you very much.
We will break at this time for lunch to give everybody a chance to be ready for the next witness. Please be back here at 2 o'clock. Is everyone able to be available at 2?
Yes, Your Honour. Can I raise one other matter?
Yes.
Whether Your Honour wishes to deal with it now or at some point later today, I'll be grateful. But looking ahead, we've of course got the evidence to be called from witness W04842. And I did raise at the outset of last week in relation to both to the witness, Ms. Pumper, who's just left, but also in relation to W04842, that we'd received an email about a witness preparation session,
yes,
which had referred, in the case of W04842, to new information. It did not refer to, it said there were to be no clarifications, changes or corrections to his declarations, but the new information had been provided. I do wish to press that if it is the intention of the SPO to seek to adduce testimony in relation to that new information as it was described, that we require a witness statement or declaration to be signed, setting out the scope of that witness's testimony in those areas, with a proper application being made for leave at the late stage to adduce that material.
Your Honor, and the prosecution had already replied on this request, observing that Rule 102 of the rules prescribe that witness statements are disclosed, but do not prescribe to undertake witness statement in order to provide notice. The notice has been provided with the summary pursuant to Rule 95 of the rules and with the notification of the preparatory meeting as instructed by Your Honor with the order on the conduct of proceedings.
Well, if that is the SPO's continued position, then I wish to address the trial panel at some length about that, because it does seem to me that there is a undue informality being approached to the approach of the SPO in these matters.
First of all, what do you mean by at length?
I would wish to take the trial panel through the rules. That would require me to develop a submission in relation to a number of the rules, to the effect we say that the rules require a party, if they are seeking to adduce testimony from a witness, to serve in advance a witness statement setting out the scope of that testimony.
Why don't you go ahead and make your submission now?
So the starting point, we say, is Rule 102 of the rules. Rule 102.1b requires the specialist prosecutor to make available to the defence, within the time limit set by the panel, no later than 30 days prior to the opening of the specialist prosecutor's case, 1, the statements of all witnesses whom the specialist prosecutor intends to call to testify at trial. 2, all other witness statements, experts' reports, depositions or transcripts that the specialist prosecutor intends to present at trial. And 3, the exhibits that the specialist prosecutor intends to present at trial. Rule 102.2 provides that any statements of additional specialist prosecutor witnesses which have not been disclosed within the time limit pursuant to paragraph 1b, and whom the specialist prosecutor intends to call to testify at trial, shall be made available to the defence as soon as possible and shall be accompanied by reasons for the late disclosure. Defence may seize the panel where grounds to dispute the late disclosure exist. Rule 102.4 continues. Disclosure pursuant to paragraph 2 shall be finalised during the pre-trial stage. Thereafter, the specialist prosecutor shall provide notice of any new disclosure accompanied by reasons for the late disclosure. Rule 102 and the obligations therein are then reinforced in relation to, by Rule 143, the examination of witnesses. Rule 1431 makes express reference to previous statements of the witness. The examining party may ask questions to the witness and may show the witness any document or other evidence in compliance with these rules. If a witness cannot recall the facts he or she has provided in a previous statement, the witness may, with the permission of the panel, be shown documents to refresh his or her memory. A witness can only be shown documents to refresh his or her memory if the witness has made a previous statement which has been disclosed. Rule 143C then again refers to the witness's prior statements because it provides that where the witness has made a prior statement, where it is inconsistent, the prior statement may be admissible for the purpose of assessing the credibility of the witness, as well as for the truth of its contents or other purposes within the discretion of the panel. Obviously, Rules 153, 154 and 155, as we have previously looked at, again concentrate on written statements of the witness for the purposes of admission of those written witness statements in lieu of oral testimony or direct examination. The whole thrust of the scheme is that if a witness is to be called to give evidence, disclosure of the evidence that the SPO intends to adduce from that witness is to be disclosed to the defence in advance in the form of a witness statement. That allows the refreshing of memory in accordance with Rule 143, and it also allows, in the course of cross-examination, the cross-examination of the witness on the previous statement that he or she has signed, setting out the content of his or her evidence. The reference or the reliance, if it is indeed relied upon by the SPO, of the additional provisions on disclosure that arise in Rule 95 to provide a summary of the facts on which each witness is expected to testify is not a requirement to make such disclosure that, in effect, removes the obligation to provide a witness statement. If that was right, then the effect of Rule 102.1 would be nullified. The SPO could avoid making proper disclosure as to the extent of their case by simply providing a summary of facts on which each witness is expected to testify. If they were to do that, and indeed be permitted to do that, then Rule 143 and the rules on refreshing the memory of a witness from a previous statement would have no effect. There would be no proper way of refreshing a witness's memory. And indeed, cross-examination would quite unfairly face the position where a witness could not be cross-examined on a previous account. Because, for example, if we look at the only information we've had provided by the SPO in relation to what is described as new information, although for reasons which will become obvious patently is not, at the moment is in the form of an email that came from Mr. James Pache. Did not come from the witness. I can't properly cross-examine the witness on that document because it's not his statement, and I cannot therefore explore any inconsistency between the witness and what is recorded there, because that is an account recorded by Mr. James Pace. We have not raised a point before about the informal introduction of the concept of a declaration by the SPO in these proceedings, as opposed to dealing with witness statements as the rules require. We have noted that even with the declarations that have been provided, not witness statements, they do at least come with the declaration that the witness affirms the following facts and information to be true and accurate to the best of his or her knowledge and belief. And we have appreciated that that declaration as to truth and accuracy is reinforced by a signature on the document. In relation to witness W04842, we have such declarations in relation to what is now a very narrow area of his testimony, and we do not, in the circumstances, ask for a witness statement in relation to the matters that are covered by his existing declarations. We are content in that we can properly cross-examine him in relation to that part of his testimony, at least, on the declarations that have been made. But to the extent that the SPO intend to adduce evidence as to what is described as the following new information. One, following the distribution of the batches, SPO witness security took measures in the field.
Slow down.
Such measures including one, relocation, moving someone to a safe house, and referring to persons to witness protection. Two, when deciding which witnesses to contact following the distribution of the batches, SPO witness security checked all the names in the materials and then contacted these persons. And three, W04842 has been attending senior management meetings on witness contacts since he became the de facto witness security team leader in October 2020. He has formally held this position since April 2021. These discussions concern what witnesses say during contacts, how the next call should be organized, and which topics would be discussed.
Mr. Rees, I think we get the gist of your argument.
That is described as new information. It's new information to us. It is not, of course, new information to the SPO, because witness W04842 is an SPO official, and he's been at the SPO throughout. The SPO, if they seek to adduce testimony along those lines, should serve a signed declaration with an affirmation as to truth from the witness on those matters, with an application for leave to adduce that material, explaining the good reason for late disclosure. Judge.
Thank you, Mr. Rees. Just a number of clarification. You received notice of these information on the 14th of October of this year, correct? That's 2 weeks ago.
14th of October, yes.
And as you properly indicated, it touches upon 3 rather narrow issues which you've put into the record. Is that right?
Well, I don't know how narrowed or wide the proposed testimony is likely to be, because I don't have a witness statement from the officer setting out what he intends to say.
Well, what I want to understand better, Mr. Rees, is the prejudice that you say you suffer from not having what you describe as a witness statement. If these same 3 items were provided to you with the addition of a signature, could you tell me what difference that would make to you in terms of your preparation? And the other thing, if you may address it at the same time, you have suggested that you can't properly cross-examine with this notification because it is not signed. Now, isn't it a possibility for you to simply take the witness to these 3 items at the beginning of your cross-examination? And again, it's not for me to direct you and to tell you how to do your job, but to ascertain whether that corresponds to what he would tell you. Isn't that a procedure that could be followed so that you would have the certainty that this is indeed his view rather than counsel's view?
Judge, in the first instance, it does not fall in our submission for us to demonstrate prejudice at this stage. We say the effect of the rules are perfectly clear, and it is not for us to demonstrate that we suffer no prejudice from the SPO ignoring the rules on early disclosure in Rule 102, 1B, to serve witness statements prior to the opening of the Specialist Prosecutor's case within a time limit. If they are late in doing so, for them to provide reasons for late disclosure. Secondly, there is prejudice, and the prejudice arises, as is recognised in the disclosure rules in Rule 102, and indeed we say in Rules 143 also, that a defendant should not be required, the SPO should not be permitted to take a defendant into a situation where a witness is entering into, as far as the defence are concerned, a voyage of discovery. That is not a fair application of the rules. That's why disclosure at an early stage of the SPO's case, which witnesses it relies upon, and which witness and the witness statements of those witnesses is to be provided at an early stage. Yes, Your Honour, I could, of course, in due course, if they are entitled to call this evidence without any witness statement from the witness, ask him about paragraphs 1, 2, and 3 in that email, and he may say that actually that's not accurate, that's not my account, and if I put to him an inconsistency in his oral evidence with that note, I suspect that is what he would say. Because in contrast with a signed declaration from the witness, who gives a different account to the witness statement that has been disclosed previously, I can't put to the witness, this is your account, you signed it, and you confirmed that it was true to the best of your knowledge and belief. Now, we're not at the stage where witness W04842 is to give evidence. I understood the position that the trial panel took at the beginning of last week in relation to Miss Pumper. She was. And I understood that there was an element of pressure involved there, but we are not in that situation with witness W04842. So I am yet to understand what is the SPO's objection to providing a signed declaration, setting out, or a witness statement, even better, in accordance with the rules, setting out the testimony that they propose to adduce from that witness ahead of his testimony.
I will let the prosecutor speak for herself, but I would think that part of her submissions is likely to be, Mr. Rees, that what you are asking goes beyond the rules, because the practice, for what it's worth, from a number of comparable jurisdictions has been that the last-minute additions or corrections to a statement by a witness who is due to provide evidence is given in the form that you have received. Now, with the caveat that that evidence should be relatively constrained in order not to cause prejudice to the other side. Thus, my question to you, Mr. Rees. Again, well, we will decide upon your application, but I would think that this is probably going to be part of our colleagues' submissions here.
Yeah.
Madam Prosecutor, you have the floor.
Yes. If I may, Your Honor, the entire defense submission is based on a faulted premise. The rule do not prescribe that only witnesses who provided previous witness statements can be called to testify. And they do not prescribe neither that questions to be put to witnesses be limited to the topics that have been addressed in a previous witness statement. The rules indicate, in Rule 95, that the opposite party should be provided notice of the facts and circumstances a witness is to testify about. The defense has been provided such notice in April, in October this year, and through the log record of the preparatory meeting, which was undertaken in accordance to Article 93 of Your Honor's order on the conduct of the proceedings. I also want to highlight that the practice of other international tribunals which have similar rule framework do confirm that there is no need to produce previous witness statements for witnesses that are going to be called to testify live when such witness statements do not exist. And I cite, for example, to Prosecutor versus Arzic, the decision on urgent defense motion to preclude GH 162 appearance until after disclosure of a proper witness statement, IT 0475T of the 17 May 2013, and similar decision of the same kind. Yeah. The defense refers to Rule 143 of the rules and refers to the fact that there is a mentioning of witness statements. The fact that witness statements may be taken, that the witness statement may be used, doesn't mean that witness statements needs to be used in the course of the presentation of the evidence of a witness live, or that they need to be used in the course of the cross-examination. The cross-examination is supposed to be on the matters addressed in the examination in chief that are notified to the defense through the ways prescribed by the rules under Rule 95 and as indicated in the order for the conduct of the proceedings. Thank you.
Thank you, Mr. President. Mr. Rees, the paragraph which Ms. Bellici just referred to as paragraph 93, in my version is paragraph 53 of the order on the conduct of the proceedings, refers to the provision of new information provided by a witness during a witness preparation session. Now, you had an opportunity to make legal submissions to the panel on that particular paragraph, didn't you?
So I have no issue with the proposition that where a witness makes a clarification or change or correction to his or her, the content of his or her existing declaration, if that is material which is disclosed to the defence on the basis that it's material to the preparation of the defence, or if it's exculpatory matter, I have no issue, certainly in the first instance, with it coming via an email. What we have here, though, is a different scenario. We have the prosecution seeking, at a late stage, to adduce whole new testimony from a witness. And I do not, if it is the practice in other tribunals, for that to be dealt with informally by way of email, well, then that is the practice of other tribunals. We know, because we've explored it, that Rule 102 and the operation of it in this court is a material advance on the rules applied by other tribunals. And we have already we've already confirmed that the disclosure regime set out in Rule 1023 is, in many respects, an advancement upon that applied in other tribunals. So I would ask the trial panel to concentrate on the practice to be developed in the Kosovo Specialist Chambers itself.
Mr. Rees, can I ask you this? If a witness comes to testify and gives evidence about a matter which is not previously contained in a witness statement, you will always have the opportunity to cross-examine the witness on that new evidence.
I would, and I'd be able to say to the witness, you were asked to make a full declaration. You were asked to sign a declaration setting out what you knew was true with all material aspects of your testimony, and you haven't put that in your declaration. That is a recent invention I can put to the witness. But I can't do that in the absence of a witness statement from that witness.
Mr. Rees, is there anything at all to prevent you putting to a witness in cross-examination information which has been provided to you in good faith about what corrections or new information that that witness provided during the witness preparation session? Is there anything in the world to prevent you putting your case to the witness on the basis of the emails that you've received?
So at the moment, if it is the case that the witness intends only to effectively give the evidence that is in the contents of paragraphs 1, 2 and 3, that's one matter, but I suspect the SPO does not intend that, and it'd be very difficult to confine the witness to do that, because I anticipate they wish to explore in much greater detail what he has to say about the matters set out in that paragraph 1, 2 and 3. And in relation to the specific question Your Honour asked about that email, yes, I can put it to the witness that somebody else took a note and these are the 3 paragraphs. But what I can't say to the witness, if the witness says, well, I know, Mr. Rees, but I said this and I said that and I said more and I did say this. This is not the first time I've said it in testimony because I told Mr. Pache. Then what I can't do is put to him a signed declaration that he made, confirming that the content of that witness statement is true, and ask him to explain the inconsistency between his testimony and his signed declaration. That is the purpose for Rule 143, which does set out what is, whether it's the approach taken in other international tribunals in this city, it is very much the standard approach taken in all common law jurisdictions. It is not by any means an alien proposition that if the prosecution wished to call a witness to give testimony, they should serve in advance a witness statement signed from that witness so he can properly be refreshed on his memory, if necessary, on the statement, or indeed cross-examined on it.
Thank you, Mr. Rees. We will issue an oral order on that before proceeding. Thank you very much. We will be adjourned now until 2:30.
All right. All rise.
Be seated. Good afternoon. Oops. Good afternoon. We're ready to start with the next witness, Mr. Berisha. I note that duty counsel for the witness is in the courtroom, Mr. Aryanit Kochi. Is it Kochi? Is that correct?
Kochi.
Kochi. Okay.
Good afternoon, Your Honor.
Thank you. For the record, the panel notes that in a decision dated 8 October 2021, that is F355, the panel permitted that the witness be represented by counsel for the purpose of his testimony and for the counsel to be present in the courtroom. Madam Usher, would you please bring the witness in?
Your Honor, I'm sorry. Before the witness comes in, is it possible to put two short matters on the record arising from the preparation session yesterday?
Yes.
Thank you. And for the record, these are both reflected in the preparation log disclosed yesterday. The first, as was noted in the preparation log, this witness who is about to come stated that there were some errors in the Albanian language interview transcript. We immediately asked that our translation unit review this transcript after that preparation session. Because of this issue and the fact that this witness, who is fluent in English, confirmed that his English interview transcript is correct, but for one spelling of one name, I will only be using English statements should there be any need to refresh the recollection of the witness in the course of today. And those are on our presentation queue. We will not be using the old Albanian transcripts from our presentation queue for that reason. Should the defense wish to use those the Albanian translation of this witness's interview, we are going to disclose a further corrected version of that today. The second matter is of two, is that yesterday the witness also said that at the beginning of his testimony he wanted to address the trial panel about how he is not testifying voluntarily. The witness was indeed summoned to appear, but I wanted to briefly address the question of self-incrimination before the witness is brought out. The SPO's position throughout is that W04866 is a witness and is not a suspect. He was interviewed as a witness, and Mr. Kochi is present today at the request of the witness. I wanted to make it clear on the record and on the authority of the specialist prosecutor himself that we will not be prosecuting this witness for anything he did in relation to this case. From the nature of the conduct to the limited scope of what he published to, most notably, his intentions throughout and effective actions to protect and return confidential information, no crimes were committed in our assessment. And to repeat, the specialist prosecutor has stated that he will not be prosecuted. The trial panel has already held that no self-incrimination assurances are necessary at this time, and the SPO continues to have no objection to providing them should the circumstances change in the course of his testimony. Your Honor, thank you. That's all I wanted to say.
Nothing in relation to the second issue, but the first issue, just to put on the record, we had raised concerns with the translation with the SPO at an earlier stage. We had requested copies of the recording so that we could verify. The interview was obviously, certainly for Mr. Berisha, was conducted in Albanian, so we will need to verify that because we have raised these concerns previously.
And when do you intend to verify that?
Well, they've said that they'll provide us with a corrected Albanian transcript. We will need to see that before we can cross-examine Mr. Berisha.
You mean you're not going to be ready to cross-examine him today?
Well, I don't know what the timeline is for those verifications.
Possibly you'll have time overnight then. Thank you.
Yes, Your Honor, if it helps for the record, they did tell us, the translation unit, that they didn't see any substantial changes in the transcript, and we're hoping we can disclose it even during this session.
Thank you very much. Mr. Kotze?
Yes, Your Honor.
Are you comfortable with us proceeding with the testimony in English?
Yes, Your Honor. But as it is Kosovar court, with your permission, I will proceed. I will speak in Albanian.
Oh, that's
So,
fine. That's fine.
It's
Just-
okay with me in English, but I will speak in Albanian.
Just be sure to pause to allow and go slowly so it can be translated.
Thank you.
I know you know that process.
Yeah.
All right, thank you very much
Thank
for
you very
being
much.
here. Now you can call in the witness.
Microphone for Your Honor, please.
All ready, Mr. Berisha?
Yes.
Good afternoon. The
Good afternoon.
solemn declaration which you are asked to take pursuant to Rule 141, Paragraph 2 of the rules. Please proceed.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and I shall not withhold anything which has come to my knowledge.
You can hand that back to the usher. Mr. Berisha, I understand you wanted to make a short statement concerning the fact that you are here to testify. Is that correct?
Yes, Your Honor. I just wanted to tell you that I'm not very happy to be here to testify in front of you. But that doesn't affect the fact that I'm going to tell the truth. I was obliged to be here, otherwise I'm not happy to be here.
You're summoned to be here, and of course your attorney is here with you. If you have any questions you need to ask at any time, we will stop and allow you to do that. Do you understand?
Yes, I do.
You may be seated. Thank you, Madam Usher. Mr. Berisha, today we will start your testimony, which is expected to last until tomorrow. As you may know, the prosecution will be asking you questions first, and once they are done, the defense has the right to cross-examine you. Members of this panel may also have questions for you. The prosecution estimate for your examination is 3 hours. The defense estimate is up to 1 day. The panel may allow re-examination by the prosecution if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat it or tell them that you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. The panel understands, as we have already said, that you have been formally summoned to appear by the prosecution in accordance with Rule 121, Paragraph 2 of the rules, which means that you have been compelled to appear for testimony. The panel also informs you that you have the right not to incriminate yourself and that you may object to providing testimony that might tend to incriminate you. You are also permitted to consult with your counsel whenever you feel that your answer might tend to incriminate you. If the panel considers that you should nevertheless provide an answer to a specific question, we may decide to compel you to answer that question. In that case, we may also decide to provide you with an assurance with respect to self-incrimination. But we will do this only if necessary, and we will inform you of the specific procedure at that time. And I'm sure that your attorney can advise you more fully in regard to these issues. So please speak into the microphone and wait 5 seconds before answering a question, and then speak at a slow pace for the interpreters to catch up. While you are giving evidence in this court, you are not allowed to discuss with anyone except your assigned counsel the content of your testimony. If any person other than your assigned counsel asks you questions outside the court about your testimony, please let us know. Mr. Prosecutor, you may start.
Thank you, Your Honors. Good afternoon, Mr. Witness.
Good afternoon.
Mr. Witness, I'll be asking you questions here this afternoon, and we'll start with, what is your name?
My name is Halil Berisha. Could the witness be asked to speak closer to the microphone, please?
Mr. Witness, I'm told you need to speak a little closer to the microphone.
My name is Halil Berisha.
Date of birth?
28th of February 1984. 94, correction.
Doberden
Klina.
In Kosovo, correct?
Correct.
Of education?
Bachelor.
I have a bachelor degree.
Do you speak?
Albanian and English.
Mr. Berisha, where were you working in September 2020?
I work for InFocus, Gazeta InFocus.
And what was your job with Gazeta InFocus?
I was a reporter and editor.
The answer over again. We're having a technical difficulty with Mr. Haradinaj's speakers. Is it working now?
I can't hear him very well, but he seems to say, I don't hear very well. I can't hear you very well, Your Honor. Maybe the speaker is not speaking to the phone, or I don't hear him very well.
Everyone, please try to speak into your microphone. Let's go on.
Thank you, Your Honor. Mr. Berisha, what was your job with Gazeta InFocus?
I was a journalist and editor.
Please describe your responsibilities as a journalist.
I found topics to write about, and on certain occasions I have edited texts written on certain topics.
And where was your office with Gazeta InFocus?
At the center of Pristina, across Bill Clinton Square.
Mr. Berisha, are you still a journalist?
For the moment, I'm not exercising the profession of journalist.
When did you stop working for Gazeta in Focus?
At the end of September 2020.
Why did you leave at the end of September 2020?
I started studies in Germany.
Berisha, as a journalist, what subjects were you writing about for Gazeta in Focus?
About daily events and various subjects. It was not a specific subject I wrote about.
Did you ever write about the KLA War Veterans Association?
Yes. As a journalist, for the subjects I wrote about, I contacted the persons that were involved in that topic or subject.
To the extent you remember, can you provide the names of those persons?
I don't know what specific case you are asking me because I wrote about many subjects.
Way. Mr. Berisha, did you attend a KLA War Veterans Association press conference on 7 September 2020?
Yes, I did. At the offices of the WVA.
Where is that?
It is in the vicinity of Pristina municipality.
How did you hear about the press conference?
I heard it from the media that a press conference was going to be held.
Now, Mr. Berisha, you were working with the media at the time. Was this something that you read, something that you heard? Can you please describe how you learned about it?
You're asking me about the conference in question?
On 7 September 2020.
We were in the morning briefing that we have every day at the newspapers, and one of the journalists said that it's possible that the WVA might hold a news conference. I tried to find out, and I did.
So if I understand correctly, someone from your office told you that this press conference was happening that day.
He said that according to some information the person had, it is probable that a press conference was going to be held that day.
Information, did you contact the KLA War Veterans Association before the press conference?
Yes. With Mr. Haradinaj.
And I previously?
As journalist that I was, I knew many people working in institutions, organizations, in this case, Mr. Haradinaj.
Why did you contact Mr. Haradinaj specifically?
Because he was always friendlier towards the media.
When you contacted Mr. Haradinaj, what did you ask him?
I don't recall exactly, but on my recollection, I asked him that we have information that you are going to hold a news conference, and is it true?
What did he say?
He told me that very soon they are going to come up with a public notice, and then in that case we might attend that conference.
After you finished this conversation with Mr. Haradinaj, what did you do next?
We tended to other things we had to do in the office until we saw a public announcement about the said conference.
Upon arriving at the KLA War Veterans Association, were there other journalists there besides yourself?
In fact, I was among the first. When I went there, there wasn't anyone else present.
In the course of the press conference, what is the most number of journalists that you saw with you?
I think there were about 10 journalists, but I am not sure.
I understand. Do you remember which media outlets were represented there besides Gazeta?
From what I remember, but nonetheless I'm not very clear about that. It was Kosovo Press, Economia Online, and I believe that there was a team from calzot.com as well, but I'm not sure about the others.
How did the press conference begin?
We waited there in the office for a couple of minutes. Then the persons that held the conference came and they started with the press conference.
Who was speaking at the press conference?
As it can already be watched in the video that is published online as well, Mr. Nassim Haradinaj and Mr. Hüsnü Gucati were the ones talking at the press conference. They spoke about some documents that were brought to the office of the War Veteran Association by an unknown person.
What else did they say about the documents?
They said that it was unexpected. They didn't expect anyone to bring those documents, but the documents were instead brought in the morning, and those were the documents that they were presenting at the press conference.
What did the documents concern?
As it was said in the press conference, it was said that the documents were from the specialist court.
Now, Mr. Witness, you talked about a video of this event. I would now like to show you part of a video. And for the record, Your Honors, this is P1. This video is already in evidence. The sound can be on, but no simultaneous interpretation is needed. The part I want to show is 14 minutes, 30 seconds to 16 minutes on the video. I am more interested in what the accused are doing than what they are saying, but the corresponding transcript pages in both English and Albanian are pages 6 to 8 in P1ET and P1AT. Now, Your Honors, because the excerpt involves displaying confidential documents, we would ask to go into private session for 2 minutes to play the excerpt. My questions about the excerpt can then continue in open session.
For purposes of protecting confidentiality, we will go into private session. Madam Court Officer.
Your Honors, we're back in public session.
Thank you. Mr. Berisha, in relation to the video excerpt we just watched in private session, is that the press conference you attended?
Yes, it was.
Please identify the people that you saw on the screen during the excerpt.
Mr. Haradinaj and Mr. Hüsnü Gucati.
The name of the third person?
No, I don't know.
Describe what Mr. Gucati and Mr. Haradinaj were doing during the part of the video that you saw.
They were looking for some documents which allegedly demonstrate the cooperation of the task force with prosecutors and with the people from Serbia as well.
Mr. Berisha, after the press conference ended, what did Mr. Gucati and Mr. Haradinaj do with those documents they were discussing?
When the press conference ended, the journalists as well as the camera person, like every other press conference, what they did is that they started to take photos and they started to record the documents because of the interest that they posed onto them.
Did you ask to take a copy of the documents?
Because of the fact that the documents were many in number, and it was not possible for us to know what those documents contained, it was impossible to shoot them all and to video record them all. Therefore, I asked for a copy of those documents. I was close to the journals, to the journalists and to the persons that were heading the conference, and it was there that I asked these persons on whether I could take a copy of the documents.
When you say the persons who are heading the conference, which of those people specifically did you ask?
I asked on whether I could take the documents. It's not that I addressed someone specifically, but there were the persons that headed the conference, and I addressed them together on whether I could take the documents or not.
When you say you addressed them together, is that in reference to Mr. Gucati and Mr. Haradinaj?
Yes.
What did they say in response to your request to take the documents?
They said I could take the documents.
You can take the documents between the two of them?
Mr. Haradinaj.
How many pages did you take, approximately?
It's difficult to know. It's a considerable number of pages, but it's about 1,000 pages, I think, 1,000.
Mr. Berisha, after you took your pages, were there other batches of documents remaining in the same place where you took yours?
Yes, from what I know, yes, there were other documents there as well.
See anyone else taking the documents while you were there?
I have not seen anyone else because I took the documents and I immediately left the place where the press conference was held.
When Mr. Haradinaj gave you permission to take the documents, did he say anything else about the documents to you?
So it was a very brief contact with him. I took the documents, like I said, it was a considerable number of pages, and it was difficult for me to hold them all. And therefore, I asked for a bag in order for the for the documents to be put in the plastic bag, something like that.
Were you told anything about making copies of the documents?
Making copies of the documents, no. But I was told that given that there are many documents, the number of copies is small, therefore they are not sufficient for all the media outlets. Therefore, if another media was asking for the same documents, I was asked to collaborate with the other media outlets if it was at all possible.
What did that mean to collaborate with the other media outlets because there weren't that many copies?
I said it before that there were too many media representatives there. There were not sufficient copies for all the journalists. When I asked for having the documents and when those documents were given to me, other media representatives were left without documents. And I was told that if any of the other media people would ask for the documents from me, I was kindly asked to refer and to give those documents to the other media representatives.
So in other words, you were asked to make copies for these other media members if they required it. Is that right?
If someone asks of these documents, I was told to share the documents with them.
Who told you that? Who told you to share the documents with those other media members?
When I asked if I could take the documents, Mr. Haradinaj answered that question, and I continued the conversation with him.
So just to be clear, the remark you were saying about how if they needed it, you should share it with others, it was Mr. Haradinaj that said this to you.
Yes.
Berisha, once you left the press conference with these documents, please describe what you did next.
The On In Focus office, where I had to go, is about 1.5 kilometers, so 2 kilometers away from where I was. So given that I had a considerable number of documents, I was just thinking that probably someone from the office would come and take me by car. In that moment in time, I had to wait, and I had a coffee in the coffee shop of the War Veteran Association, in a coffee shop that is nearby.
At what point after the press conference did you first inspect the documents you had been given?
Can you repeat that again? I didn't understand the question.
At what point after the press conference did you inspect the documents that you took with you from the press conference?
After I went in the offices of the In Focus newspaper.
When you inspected the documents, what did you see?
It it was a problem because, like I said, the documents were many in number and they were not in a sequential order. Therefore, it was a problem to understand what it was that those documents contained.
Were you able to assess the classification of those documents?
For me, as a journalist, it's not easy for me to know on whether the documents were confidential or not, because I don't have any tools to identify that. However, in some of the pages of the documents, there was this marking confidential.
How long had you been inspecting the documents before you noticed that classification?
Your Honour. The witness referred to markings as opposed to classification. Perhaps the question can be rephrased by referring to the words used by the witness rather than putting words in his mouth.
Happy to do that.
Sorry, I'm sustaining your, I don't know if it was an objection, a request for clarification.
Happy to do that. Mr. Witness, you said that on some of the pages there was a marking confidential. Do you remember after how long you'd been inspecting the documents before you noticed those markings?
I do not remember. So we first took them and we started inspecting them in the office to see what they contained. So it was probably after half an hour to 45 minutes that I saw them.
Once you realized that there were confidential markings inside the documents, what did you do next?
As a matter of fact, we had suspicions about the authenticity of the documents because in a moment in time when we received the documents, we sent an email to the SPO to ask about those documents. And so the answer was not an answer because they told us that we can't comment on these documents. And given that we are in such a situation and we were suspicious about the confidentiality issue and the authenticity of the documents as well, so we decided to not deal with these documents up until there was some clarification on the matter.
When you said that you would not deal with the documents, did you store them while you figured out what to do with them?
As a matter of fact, we had some articles about the documents. So at least we try to be cautious about those documents that had this marking confidential, although we had our own doubts about confidentiality and about authenticity of the documents. So we try to be cautious not to publish those documents, whereas we put these documents in the space that was the safest there in the premises of InFocus.
Where was that? Where was the most secure place in the InFocus premises?
In the office, where the director and the administration stay, and the place where the financial documents of the company, I mean, that's the most secure spot in the premises of the InFocus newspaper. So it's not that we have any special place for documents of an important nature.
When they were stored in the director's office, who had access to them?
The InFocus newspaper is a media outlet that has a big office. I mean, the journalists are there located in this big office. I mean, there's a meeting room as well and a room for the director. So everything is open for the three parties, namely for the editors, for the journalists, and for the director. So usually, journalists don't go in the office of the director or other people that are working for the newspaper. They don't go in the director's office without the presence of someone else in that office.
To the best of your knowledge, were any pages added or removed from those materials during the time they were in possession of Gazzetta in Focus?
To my knowledge, nothing was added or removed from those materials.
Now, Mr. Witness, I believe you said this already, but just to confirm, did you contact the Specialist Prosecutor's Office that you had these documents?
As far as I remember, we exchanged emails 2 times with the Office of the Prosecutor. They were informed. We initially asked them whether these documents were coming from the address that was on them. So we wanted a confirmation from them whether these were their documents.
Mr. Berisha, during the time that these pages were in the possession of Gazzetta in Focus or afterwards, did Gazzetta in Focus ever receive these same documents distributed by the KLA from any other source?
To my knowledge, no, there was no other source for these documents.
Now, Mr. Witness, you mentioned 2 emails you exchanged with the Specialist Prosecutor's Office. I want to show you an email now. This is from P98 MFI, and the pages are 091915 to 091916. Now, Your Honors, I can see, I'm not sure Mr. Kochi has a copy of the emails that I'm about to show. I have a hard copy of all of the exhibits. If it would be helpful, I'm happy to provide this to duty counsel.
Mr. Kutsi, do you need a copy of these documents?
Could I get the assistance of the court usher, please? And the defense is welcome to inspect them as well. It's just the materials from our presentation queue in hard copy.
We'll get them to you, Mr. Kutsi, eventually.
Within this bundle, there are articles that, as far as we understood at least, do not relate to this witness. The bundle also contains copies of official notes drafted by an operational security officer, Miss Pumper, who gave evidence, concluded her evidence this morning. In fact, there's one official note, and indeed Miss Pumper's declaration, together with the official note from the operational security officer. Not sure as to why those documents are in a bundle for this witness.
I thought we had some emails you were talking about. This is a lot of other stuff.
Your Honor, what has been given to the Gucati defense at the moment is just a reproduction of our presentation queue in hard copy.
I see.
These particular emails, there is a declaration from Ms. Pumper at the beginning of them. And there are emails from a variety of different people, of which we'll see how many the witness actually authored. We're only going to show him the pages that we believe he authored.
I'm grateful for that clarification.
Thank you. Show them to Mr. Kutsi.
Yes, and for the witness, he can look at the screen, and from P98 MFI, we're interested in pages 091 to 915.
Excuse me, wait till Mr. Kutsi is finished.
Oh, of course. And for the benefit of Mr. Kochi, we're talking about its tab 325, which is the exhibit list number for this item.
I don't know that he heard you. Mr. Kutsi, it's Exhibit 325.
Yeah.
And the page number is 091915, and it's on the screen. I'll wait a moment for Mr. Kochi to get oriented before I continue.
All right?
Yeah.
Now you may proceed, Mr. Howling.
Thank you, Your Honor. Mr. Brescia, do you recognize this email?
Paul.
Yes.
One of the two emails that you wrote to the SPO?
Yes, this is one of the two emails that were sent to the SPO, that we decided to send to the SPO.
The next page. That's your signature, correct?
It's my name and my position within Gazeta in Focus.
I follow. To go to the next page, and this would be 091917. Mr. Brescia, do you recognize this email?
Paul.
Yes.
Write this email to the SPO?
I sent this email from my own email address, but the email itself was composed and written together with the editors.
And why did you send this email?
We sent this email because the first response of the SPO, because in fact I don't know if I can call it an answer since they did not provide any information. They just said that they cannot discuss the documents. As I mentioned earlier, we were not sure about the authenticity of the documents as well as about their confidentiality. That's why we wanted to be sure, and that is why we informed the Office of the Prosecutor, Specialized Prosecutor.
Mr. Witness, where it says in the video, in the email, so we locked the documents in the safe place and we would like to inform you about this. Is that what you were describing earlier about storing the documents?
Yes.
Your Honors, at this point, we would suggest that the MFI designation can be removed for P98 in respect of the 3 pages just authenticated by the witness. We are mindful that the whole document is MFI'd at present, so our suggestion would be to either admit this part of the exhibit as a kind of decimal of the old exhibit, like P98.1, or to just give these 3 pages its own exhibit number, as the trial panel prefers, but we would be tendering these 3 pages at this time.
No, I agree with the suggestion from Mr. Honey.
Also concur.
We will refer to this as 98.1. No longer using the MFI, it is admitted.
Thank you, Your Honor. And although P98 MFI still has a confidential classification, P98.1, as you've described it, can be public.
Yes, all right.
Can I just check? So that's what was formerly ERN 09195 to 091917. Now P98.1.
Indeed, yes.
Thank you.
Thank you. And any objection to the reclassification as public?
No.
All right, it is reclassified as public.
Thank you, Your Honor. Now, Mr. Berisha, did the Specialist Prosecutor's Office collect the batch of documents that we've been discussing?
Yes, 2 persons who introduced themselves as investigators of the SPO came.
And this was on 9 September 2020, is that right?
To my recollection, yes.
Please describe the interaction you had with the SPO when the documents were collected.
At the outset, I was called by someone from the SPO, from a Dutch number, and I was asked whether 2 investigators could come to our offices and collect the documents. I said they could. Then they called me. We arranged a meeting because I think they didn't know exactly where our offices were. They came to our offices, stayed for about an hour, if I'm not mistaken, and before they saw the documents, we asked them to identify themselves, to produce a document, identification documents. They did so. We saw that they were representatives of the SPO. We took then the documents from the place where we had stored them, they inspected them, and then they said that they would take them with you. And this is what they did. They took the documents and left.
Did the SPO take all of the documents you took from the KLA War Veterans Association?
Yes, they took all of the documents that we had taken from there.
Was it publicly known that Gazeta had returned these documents to the SPO?
Yes, it was made public that investigators from the Office of the Specialist Prosecutor came and collected the documents.
Did anyone from the KLA War Veterans Association react to you returning these materials to the SPO?
Nobody from the KLAWVA called me on the phone, neither did we have any contact with them on this matter.
Did anyone from the War Veterans Association make a public comment about this?
You mean about the fact that they took the documents, the SPO?
Yes, that you gave the documents to the SPO.
I don't remember whether anybody made any comments on the fact that SPO came and collected the documents.
Your Honor, the witness just said that he doesn't remember. With your leave, I would request permission to show him page 20 of part 1 of his SPO interview, the English transcript. And it would be lines 18 to 25.
May do so.
Thank you. For the benefit of Mr. Kochi, this is tab 496 in the binder, and the ERN is 102781-TRET, Part 1, Revised 1. Mr. Berisha, I'm going to read you a question and answer from your SPO interview from August, and then I want to ask if this refreshes your recollection on this point. Question. So there were TV shows where representatives of the KLA War Veterans Association said what? Answer. They, so the War Veterans Association's representatives said in these TV shows or programs.
Could the counsel please slow down when reading?
Guided, that had these documents been in relation to, or had they contained information about the War Veterans Association, be that sensitive information, the journalists would not have hesitated to publish them. However, this did not happen. Any of the journalists did not publish these documents in this case. Mr. Witness, is that an accurate statement I've just read to you?
Microphone, please. Was your question whether this was my statement?
My question is whether what I just read to you, does it refresh your recollection of any public comment the KLA War Veterans Association had said?
Yes, but this is not an answer to the question I was asked. The question posed was whether there were reactions on the fact that we handed over the documents. And the answer quoted here was not the answer to your question. What I was saying there was that there were reactions on TV shows on non-publishment of the documents, but not on their handing over to the SPO.
I follow you. So was this public comment the War Veterans Association criticizing Gazeta for not publishing these materials? Is that correct?
This is not the way I understood it. I did not understand it as a criticism against Gazeta Infocus. It was not specifically directed at Gazeta Infocus, but in general to all media outlets and journalists.
Mr. Witness, did you understand such statements to be referring to Gazeta as well?
We were open from the moment we took the documents, so it was public knowledge that we possessed the documents. And we are journalists, we are media outlets, so we belong to that larger group of media outlets and journalists.
I understand that, but statement was that there was a remark about certain media outlets not publishing the materials. To your understanding, was that remark from your interview in relation to Gazeta in Focus as being one of the media outlets not publishing the documents?
Your Honour, isn't that a question for someone else as opposed to this witness? In particular, the maker of such a statement, if there was such a statement.
Yeah, you are asking him to assume something that he doesn't necessarily know. Somebody else might know it, but he doesn't know who they are actually criticizing because they don't say who they are actually criticizing.
My question is in relation to whether the witness understood the remark to be in reference to his media outlets.
Well, but he may be wrong. That's not, that question is not probative of anything.
I'll move on. Mr. Witness, you mentioned that the SPO came to take the documents from Gazeta in Focus. I now want to show you a document. This is P100 MFI. In the binder of materials, it's tab 2. Mr. Berisha, do you see your name on this page?
Po?
Yes.
Po.
Yes.
What is this document?
Ky është dokument?
This is a document that was given to us by SPO representatives after they took the documents, the document that we had to sign confirming the handover of the documents.
Mr. Berisha, where it says content, it says the words documents from KLA WVA. Do you see that?
Po.
Yes.
To the files that we've been discussing that you handed over to the Specialist Prosecutor's Office. Is that right?
Po.
Yes. This refers to the files that the Specialist Prosecutor's Office investigators took from InFocus newspaper.
Your Honors, at this point, the SPO would request to remove the MFI designation and to admit P100 as an exhibit.
No objection to that.
No objection, Your Honor.
P100 is admitted.
As to the classification of the exhibit, this exhibit is currently classified as confidential to protect the identity of SPO staff member W04876. W04876's application to be added to the witness list is pending. Should it be granted, we have no objection to reclassifying this exhibit as public.
We'll defer on the reclassification then.
Now, Mr. Berisha, did you go to any other press conferences of the KLA WVA in September 2020?
I was not present in any other conference other than on the day when the arrests took place.
Before the arrest, did Gazzetta attend any of those other press conferences?
I did not take part in any other press conference, but to my recollection, also nobody else from our Gazette took place in them.
Why didn't you go to any of the other press conferences?
Pse nuk shkuat në konferencat e tjera?
Focus nuk është
Because the In Focus Gazeta it doesn't employ many journalists. Mainly we work from the office. So we followed the first conference and decided not to attend the other conferences.
po edhe nuk e kemi
So we didn't deem it appropriate to go.
Mr. Berisha, in your capacity as a journalist, did you write press articles concerning these KLA War Veterans Association press conferences in September 2020?
Yes.
How many did you write, approximately?
It's a problem for me to give you a certain number because usually during the day I wrote about some 30 or 40 articles on various subjects, so I can't give you an accurate number.
And when you say 30 or 40 articles on various subjects, were these still 30 or 40 articles related to the KLA War Veterans Association's activities in September 2020?
ju domosdoshmërisht
Not necessarily. We covered many activities, many events, so we dealt with many topics simultaneously.
Can you approximate how many articles you wrote that month about the War Veterans Association in particular?
është prapë shumë vështirë me
It is again very hard for me to say because in a day I would write about 30, 40 articles, but I wouldn't say that the number of the articles I wrote on them was more than 10 in a month. That month.
Focusing on this subset of the articles that you wrote, did you publish any articles about the batch of documents you personally obtained?
Yes.
When you were publishing these articles about the materials you'd obtained, were the materials still in your possession at the time?
To my recollection, and I am quite certain, that the articles we wrote on these documents were written during the time the documents were in our possession. We continued to write about this issue, but not about specific documents that we did not possess.
Did these articles that we're talking about now include pictures of the batch of documents you'd received from the War Veterans Association?
disa
Some, yes, but I am repeating, even though we did not know whether the documents were authentic and confidential, we took care to edit the place in the documents which might be confidential.
Now, Mr. Witness, I'm going to show you a number of media articles now. We'll do as many as we can by 4 o'clock, and then we'll do the rest in the first session tomorrow, where I can already promise I will comfortably finish my direct examination. I am generally going to ask in relation to these articles whether you wrote them, what they are about, and for those that you did write, and the extent you can explain without revealing confidential sources, how you came to know what was reported. And I wanted to start with P125 MFI, and specifically pages 081, 361 to 081, 362. This is tab 40, or at least exhibit list number 40. The English transcript of this is tab 39, and it has the same ERN with an ET. Mr. Witness, do you see this article?
Po.
Yes.
Did you write it?
Ashtu siç po shkruante autori emrin jam, unë jam autori I këtij teksti I cili më pas është redaktuar.
I have authored this article, which was afterwards edited by the editorial board before publishing it.
When was it written?
Është problem.
It's an issue for me to give you an accurate date and time, but usually the texts that we publish were written within the same day. So probably I see the date the 7th of September, and it must have been written on the same date.
Thank you. Now, Mr. Witness, on this page, there's a part of the English transcript that I want to read. It says, "In Focus newspaper has secured evidence by which the Special Investigative Task Force, under the framework of the Special Court, is suspected of requesting evidence and testimonies from Serbia." Mr. Berisha, is that sentence in your article in reference to the materials you obtained from the War Veterans Association?
Yes, it is one of the documents that were part of the dossier.
Can we please go to the next page? Please describe what this picture is.
Kjo fotografi
This picture is a picture of the document that speaks about the text we wrote about and where we edited some of the data that we deemed to be sensitive.
So I'm correct, this is a picture from the batch of materials you obtained from the War Veterans Association.
Po.
Yes.
I would now like to turn to the next article, which is 081364 to 081367. It's in the same batch of materials, but it has which would be MFI P125. But the English transcript of this one is got an ET at the end of the ERN I just read, and it's in tab 41. Mr. Witness, do you see this article?
Po.
Did you write?
Yes.
Po sikur.
Yes. Just like the other article, I was the author, and it was redacted by the Focus editorial board.
Please describe the picture that we see on this page.
Këto janë dokumentet që I ke. Po. Këto janë dokumentet.
these are the documents we obtained, and after we returned to the office, as far as I remember, I'm not sure about the total number of documents, we took pictures of the documents we obtained.
So am I correct that these are pictures of the documents you obtained on 7 September 2020 from the War Veterans Association?
Exakt.
Correct.
Mr. Witness, is this also pictures of those same materials?
Pålek Jörns fotografi.
Yes, it's a picture of the same documents.
Same question, Mr. Witness, are these also materials from the same batch?
Yes.
One more time on the last page. Same pages from the same batch?
Pa.
Yes.
It is admitted.
I'm glad to hear that. I have it recorded differently. Yes.
There's no objection to this article. It's produced by the witness, properly admitted in any event.
Yes. Okay. Thank you.
Thank you. Your Honor, there's one longer batch of media articles that I would have, and they would all be in a row, and then at the end of that I would finish. It's going to take a little longer than 10 minutes, but I'll be able to comfortably finish tomorrow. I don't know what you would like me to do. I can start now and then end at 4. We can extend as you wish.
Well, I would just assume you use the 10 minutes you have, or as much as you can. I'm sorry.
There is one other matter that we need to raise, so I'll just remind Your Honour of that.
What's your wishes? Mr. Reese, can you say in public session what that is? Could you say in public session what the matter is?
It relates to the oral order that was made regarding the 3 officers' notes made by 2 SPO officers that were excluded, and which the SPO were to give an indication as to their position by yesterday. We have a direction to give an indication by today. So it's that I wish to raise. I'm being cryptic because, of course, we've been told to use, not to refer to...
No, you're saying right now you have not
name.
received a comment from the prosecution.
No, he has.
You have?
Mm-hmm. We have,
oh.
But we need to give our indication in response, as it were.
Okay. And how lengthy will that be?
It won't take long to give that indication.
Another
what we do next.
2 minutes?
Sorry?
Another couple of minutes?
A Welsh couple. Yes, it depends on where the trial panel wants to go next with it, as it were, but certainly given the indication we can do quite quickly.
I think we'll allow Mr. Berisha to have the rest of the day off then, and we'll finish up. Mr. Berisha, you'll need to be back here at 9:30 tomorrow for us to begin. Do you understand? And we appreciate your being here today and your candor in discussing these matters. So you will be excused. The court usher will take you out. And Mr. Coetzee, thank you very much for your attendance. Mr. Coetzee, you are free to leave as well.
And Your Honors, just before Mr. Rees makes his submission, the translation I was speaking of at the beginning of the session has now been disclosed.
I can certainly confirm that I have received them, but obviously not being an Albanian speaker, I will have to take instructions on that.
By morning we can get an answer.
Absolutely.
All right. Okay. Go ahead, Mr. Rees.
Yesterday, we did receive notification from the SPO of a written request. It's called the prosecution's second request for additions to its witness and exhibit lists with confidential annexes 1 and 2. It's filing F00396 and annexes A01 and A02. The decision or the intention of the SPO is to seek permission to add one witness of the 2 that were referred to in the oral order. So not both, not neither, but one of them, W04876. And the request goes beyond the scope identified by the trial panel in the oral order, which made it clear that the prosecution were being given permission to reflect, as it were, on calling the 2 individuals for a limited purpose of question in respect of 3 identified reports. The oral order then gave us until close of business by today to give an indication whether we have any objection to these 2 individuals being added to the witness list. Complying with that order, we indicate that we do object to the SPO's detailed request to call 1 witness and add exhibits and adduce testimony that goes beyond the scope of the oral order. Clearly, we have not had a great deal of time to deal with a written filing to respond in detail to what is not a straightforward request from the SPO. And if the trial panel wishes us to put our submissions in writing as opposed to at some stage dealing with this in oral argument, we would ask for sufficient time to be able to do that. Clearly, the SPO were given some 6 full days to clarify their position. We've been given less than 24 hours to respond.
Is it possible for you to respond fully by Thursday?
Yes, depending on what other work is envisaged. But if, as I anticipate, at the moment, as I understand it, we're intending to finish with this witness, and then there'll be no further live evidence this week, in which case, then yes, we will be able to, and we'll be grateful for that time.
So just so I understand, the prosecution is only asking to bring 1 of those 2 witnesses.
That's correct, Your Honor. The only other thing I would mention is we have no objection to them being given a written submission or further submission on Thursday. We are still planning to call the next witness. This witness is not going to take all week, and W04842 is ready to start on Thursday.
And am I understanding, or maybe you should tell me what the basis of your objection is? Just in general, you'll be allowed to make a written documentation, but I just am interested in.
Yeah.
Are you saying 1's not acceptable, 2 is?
So, dealing with the application that's before us, and there may be a different position taken if there was an application to adduce both witnesses, but there isn't. On the application before us, we will object, firstly, to the state of the disclosure in relation to the witnesses proposed to be added to the list, W04876. We object to the proposals as to the scope of that witness's testimony because of the very limited nature of that witness's role compared to what it is proposed to ask the witness about. We will raise objections to the way in which witness preparation sessions have been conducted in relation to that witness, making reference to specific parts of the order on the conduct of proceedings, filing F00314, which we say the spirit of which, at least if including the letter, have been not obeyed, leading to potential prejudice.
That's good enough to let us know what the basis of your objections are. We'll give you until Thursday to file a written response. You can file a consolidated response if you wish to avoid duplication, and there's no need for a reply as far as the court's concerned. We'll take that up Thursday, possibly have it first thing Thursday so that we can deal with it.
Thank you. I'm grateful for that, Your Honour.
Thank you.
Can I then deal with the rest of the timetable for this week?
Yes.
It was of some surprise to us that the SPO have just indicated that they would intend to go on to call the officer with the pseudonym W04842 this week, following the conclusion of the evidence of Mr. Berisha. We, of course, have raised the issue about the absence of a declaration or witness statement covering the three areas. I'd ask for the court to rule on that. If that witness is available, I struggle to understand why the SPO wouldn't just ask him to prepare a declaration or witness statement, frankly. But I'll await the trial panel's ruling on that matter. But it would place us in difficulties in preparing cross-examination. Certainly, I think it's difficult to see how we could complete that witness's evidence. Perhaps if he was called, he could deal with matters in chief. That would allow us some time to actually see what testimony he's going to give. But I can't prepare a presentation cue in the absence of a proper witness statement because I simply do not know what he's going to say.
Well, we've tried to be reasonable whenever necessary. If you need some time, we can give you some time. We would like to finish this week with the prosecution's case, but if we don't, we don't. We'll deal with it. We're going to be meeting again next week on Thursday and Friday, and we can perhaps finish up then if we have to. So let's just deal with the issue we've got. The prosecution will call the witnesses they can. I'm questioning whether you'll get to cross-examination by
Thursday. I'm given forewarning, as it were, that if it got to that stage, I would be asking for us not to move into cross-examination with that officer and reserve that until we return next week.
And we'll see where we are and rule on that at the time. We don't want to put you in a bad spot, and have tried not to.
Thank you.
All right, it's 4 o'clock. Yeah, Mr. Cadden, I'm sorry, I didn't mean to ignore you.
Just to clarify the scheduling, you said we're sitting Thursday and Friday next week. I just want to confirm. I thought I had it in the diary as Wednesday and Thursday, not Thursday and Friday.
Oh, you're absolutely correct. No, it is Thursday and Friday.
It is Thursday and Friday.
Because the other trial panel is going to be sitting Monday, Tuesday, and Wednesday. So we are sort of stuck into a fuller week than we would normally do because it's a bit difficult for the translators to have that many days and that many hours. But anyway, next week, that's sort of where we are, and it will be Thursday and Friday.
Great.
So we will see you all tomorrow at 9:30, and we are adjourned.
All right.